to remind members of the relevant provisions of standing orders in relation to this sort of statement. The maker of the statement complied with Standing Order 17 and gave notice of his wish to make the statement by 5 p.m. yesterday, and indeed supplied a copy of what he proposed to say. But under Standing Order 68, when a member of the States is to make a statement on a matter for which he or she has responsibility as an office holder, or on a public matter for which he or she otherwise has such responsibility, he or she shall A, give the text of it to the greffier, and B, advise the greffier whether the text is to be distributed to members of the States before the statement is made or as soon as possible afterwards. And in the absence of a clear wish on the behalf of the statement maker to have it sent by the greffier as soon as it's received, the practice has grown up that the statement is provided to members just before it's made. And that's what occurred in this case. And of course, if members wish to adopt a different practice, then that's a matter for PPC and members, but that's what occurred in this case. Yes, Minister, do you want to wish to resume your statement?
So, yeah,
all members have a copy to hand.
I think the climax has been somewhat taken away.
Yes, I'm sorry about that.
So I apologise to members. I understood it was automatic, that it went through to members, so we supplied it yesterday to the greffier. I'll continue. For the private sector, the Better Business Support Package grants totalling £20 million are now being used to stimulate investment in businesses to improve employer productivity and competitiveness. The first of these grants has already been issued, and I urge companies large and small to take up this opportunity to reinvest in their businesses. The Better Business Support Package is open to all private sector employing organisations in Jersey, and will see almost £5 million delivered in productivity grants open to all employers, £4 million pumped into apprenticeship schemes, an additional £2.2 million to support our rural and marine sectors, and £8 million pushed into the visitor economy, including for projects to improve productivity in the hospitality sector, new funding to Visit Jersey, and the development of new air routes, including to Europe. Connectivity, sir, is key to our island's success. The more accessible we are, the more able to succeed we will be. The award of the ferry contract to DFDS will see £300 million invested in new ferries within the next 6 years. I struggle to think of an equivalent level of inward investment ever being made in Jersey. Whilst there are teething problems with any change of this nature, the contract will see Jersey provided with a key part of its infrastructure, that being a reliable ferry service that serves the island's many needs. Similarly, we've refinanced the agricultural loan scheme, which has also begun providing loans to our agricultural sector to make much needed capital investments. The rural and marine economies are vital parts of a diverse economic ecosystem, helping us protect Jersey's environment and playing a key role in improving the health of islanders. The Financial Services Competitiveness Programme, which has been announced by the External Relations Minister this week, will enable the financial and professional services sector to remain the engine at the heart of our economy. Changes to reduce red tape are well underway across departments. One example in my department being the modernisation of the licensing law, which is now in law drafting and will be lodged for States members to consider later this year. Separately, through other partners within our customer service training programme, staff in hospitality and retail businesses have been receiving free training, which will raise the level of customer service in Jersey and invest in the skills of islanders. Hospitality and retail are also being supported by investment in the public realm, something which this government is prioritising and will, in the coming months, bring forward plans to accelerate. There has also been good progress on necessary legislation to lease part of our maritime zone for an offshore wind farm. Once it is operational, Jersey should be able to export energy into the European grid and so raise tens of millions in annual revenues. By 2040, I am sure those revenues will be supporting our public services and reducing the pressure to tax our working population. Further diversification, sir, is being achieved as we see the medicinal cannabis sector move into revenues. This has also led to Jersey attracting businesses in the biotech sector, and as a result, we are developing a cluster of firms that operate within this high-value, low-footprint area. Overall, sir, we've completed 70% of the short-term actions we committed to in the FEP delivery plan, and the remaining 10 are all underway. We've also begun work on 44 out of 45 medium-term actions, and 6 have already been completed ahead of the December 2026 deadline. We've also commenced 3/4 of the long-term aspirational actions which will be carried forward by future governments. Sir, to conclude, we are addressing the challenges raised by our ageing population, but these are long-term challenges, and this report is just a milestone on a journey that will take the next decade and a half. Change is not easy, but it is crucial. Jersey has many, many qualities, and we need to build on these, viewing the economy as an entirely intertwined ecosystem by remaining international, innovative, highly skilled, and outward-looking. We have made a positive start, but it will be for future ministers and states assemblies over the next 15 years to continue that progress. The Future Economy programme is about more than just economic growth. It is about creating an island that is attractive to live and work in, whilst remaining at the forefront of business thinking and being prepared to consider significant development, particularly in regard to infrastructure. I'm excited about working to deliver an economy in which all islanders can see their future, where exciting careers in diverse sectors are possible, and where our public services are well supported without needing to raise taxes. By achieving this, we will be able to continue Jersey's incredible success story, which has throughout time been dependent on Jersey maintaining an entrepreneurial culture that adapts and flexes quickly to the needs of business, society, and the international environment. So that is my statement, but I'd also like to add my thanks to my fellow ministers, because the work is across government. Whilst it's being led by the Economy Department, it is across government, and it cannot be achieved without the participation of the whole Council of Ministers. Thank you, sir.
Thank you, Minister. Now move on to 15 minutes of questions, and the first question is from Deputy Morel.
Thank you, sir, and I thank the Minister for the update. One of the aspirational parts of the Future Economy programme was a tunnel to France to help provide regular transportation links and also to ease affordability issues within the island. Could the Minister include an update as to progress on that project?
I thank the Deputy for her question. Yes, in the previous Council of Ministers, we undertook a basic study into the possibility of fixed link to France, and in that first piece of work looked at what type of fixed link would be preferable, and the choice or the recommendation from officers was a tunnel. It's correct, this Council of Ministers, the next stage would be a feasibility project. This Council of Ministers hasn't chosen to take that forward at the moment. But I do think it is something that the island should look at, particularly in terms of if you want to solve a housing crisis, if you want to make sure there are no delays in food arriving in the island, and if you want to make it the easiest possible way for tourists to reach the island, then a fixed link, a tunnel, would likely solve many of those problems. Thank you, sir.
Supplementary?
Thank you, sir. What is the rationale of the current Council of Ministers for not allowing this work to progress?
Minister.
I don't think there was any particular rationale at the time. Obviously, there was a change of government. It was a tumultuous moment for the Assembly and for the Council of Ministers. Costs are certainly something that this government is seeking to bear down on, and I do believe that the feasibility study, to do it properly, would likely have cost many millions of pounds. So whilst I cannot say that that is the reason, I think that that is an understandable reason that something of this nature would be paused for potential future government to pick up.
Deputy Tadier.
Thanks, sir. At the bottom of page 1, the Minister talks about right-sizing of the public sector. What does he mean by right-sizing? Does that mean a smaller public sector or a larger one?
Minister.
I think it means a public sector that's appropriate for the size of the island. And I think, as listening to the Chief Minister's questions without notice earlier, and at the current moment, because of the size of expenditure in the public sector, that would mean in very general terms, a slightly smaller public sector.
Supplementary?
Thank you, sir. A slightly smaller public sector. And so does the Minister agree that a reasonable interpretation of the 3 points attached to the smaller public sector would actually be to interpret it as meaning a cut to government services, to privatise services and then funnel taxpayers' money to the private sector, and to introduce stealth taxes? Is this what he's proposing? And if not, What do those 3 points at the bottom of page 1 mean in reality?
Minister.
I thank the Deputy for his supplementary question. I don't make decisions on any of those matters that the Deputy spoke to, so I can't say exactly how the right sizing of the public sector will unfold. That is a piece of work undertaken by others within the Council of Ministers and the States, and indeed the States Employment Board. But from my perspective, the Deputy mentioned the private sector. And one thing that I am absolutely convinced about is that if Jersey is to remain a low tax jurisdiction in terms of tax, the basic tax rate at 20%, which I've always personally felt is a fair tax rate. I've grown up with it, I guess, in Jersey, and it's what I've always felt. We will need to rely on the private sector to deliver in many different ways, whether it's infrastructure, whether it's economic growth. There are many different areas in which the private sector, we need them to become partners with government to deliver these things. I have a critique of the last 20 or 30 years in Jersey, and that critique is that the private sector has stepped back or been pushed away as government has grown. And that is just a recipe for higher taxation. But I don't believe an island of our size and our scale could cope with the economic impact of higher taxation, because it would almost certainly force businesses outside of the island.
Deputy Renouf.
Thank you, sir. I thank the Minister very much for the update. I think I'm correct in saying that there was no mention of digital in the statement, and I wonder if the Minister could speak to the importance of digital transformation in the future economy of the island.
I thank the Deputy for his question, and I'll come out straight with an apology. I hadn't spotted that, and I do apologise, because even as I sit here, there was definitely something about digital in here previously, as far as I can remember. So no, technology, I won't even just talk digital, technology is vital to the island's future economic development, and indeed, I'd say social development as well. We need technology in order to help us gain that productivity increase that we need. And so whether it's digital technology or any other technology, they are absolutely at the heart of what this island needs to do.
Supplementary.
Yes, sir. Can the Minister address the role of Digital Jersey in that digital transformation? How important does he think that is?
Minister.
Thanks, sir. Currently, Digital Jersey plays an important role in particularly driving innovation and helping the island understand what is possible in terms of digital. The Impact Fund, which is the £20 million fund, is already starting to help businesses in Jersey apply technological solutions to some of our most difficult problems. That in itself is an extremely important role.
Deputy Ayer.
Thank you, sir. Staying with the business support package, he mentions £8 million will be pushed into the visitor economy. Could he expand slightly on what projects that will actually involve? And also it says new funding to Visit Jersey. Exactly what proportion of the 8 million will be going to Visit Jersey? Because I understand their budget is quite large already. Thank you, sir.
Minister.
Sir, I'm particularly interested in that last part, the last statement by the Deputy, purely, sir, because I met hoteliers yesterday afternoon. Their opinion was not, the Deputy's opinion was not shared by hoteliers. They feel that we need to provide more in the way of marketing and funding for marketing of the island, destination marketing of the island. With regard to the specifics around the £8 million, and there is, within the Better Business Support Package, whilst we have funding available to all businesses, and I forget the exact amount off the top of my head, and I apologise for that, we have a separate part which is purely for the visitor economy, and that was to ensure that those hospitality businesses, which are significantly affected by the rise in the minimum wage, have access to investment support that is designed specifically for them. But in doing that and saying that, we also made sure that retail and other adjacent areas of the hospitality industry were included. So it's not specifically just for hotels, it's also for that wider amount. In terms of funding for ongoing, for the air routes and things like this, I think it's £1 million per year to the to Ports of Jersey to help develop air routes, particularly to the south, to Europe, and also an extra £1 million a year to Visit Jersey to help with the marketing element. I think that's really important. Going back to that statement the Deputy made about Visit Jersey receives a lot of money. Visit Jersey has received approximately £5 million a year for the last 10 years. Inflation alone tells you that that £5 million is worth a lot less today than it was 10 years ago. And so it's really important that we do keep up with the cost of increased cost of marketing. Buying advertising space, etc., is more expensive now than it was 10 years ago. So I do think there is a need to adjust the budgets for Visit Jersey, and this is one way in which we've helped on a short-term basis.
Supplementary?
Yes, sir. So is it the intention of the Minister to upgrade the Visit Jersey budget in the government plan due to inflation, on top of the 1 million extra that it's receiving? Thank you.
Minister.
I haven't come to a conclusion on that yet, sir. I think that's something that I consider, but I have no conclusion in mind.
Deputy Wilson.
Thank you, sir. The Minister speaks of improvement and plans, and I'm told that some businesses are facing a summer season of uncertainty and missed opportunities now because of the ferry situation in particular. What areas of the economy does he believe are delivering improved productivity and improving the revenue position for the island? And are there any areas of the economy where he has concerns that the investment made already is not delivering on those requirements? And what will he do about it?
Minister.
Sir, it's far too early to tell whether the monies which have been paid out or invested already have had that return. I do think that in areas such as the Impact Fund, I think that's been going for a couple of years now, and I believe we're starting to see the value of that, sir. And certainly in many areas of the economy, I'm thinking financial services in particular, they're using technology constantly to upgrading their technology to increase productivity in those areas. I think we do have areas such as construction where there could be significant increases in productivity, particularly from adopting different methods of construction. Jersey is still very tied to specific methods of construction, and that's not helpful to this island. The construction sector is fantastic in that it has a strong multiplier effect. So £1 spent in the construction sector delivers £8 to the economy, if I remember rightly. And so in that sense, it's a very important economic driver in Jersey. But it does appear that as far as productivity is concerned in the construction sector, a fair bit of work can still be done to improve productivity there.
Supplementary? Thank
you, sir. I appreciate it's quite a challenge, and certainly the conditions for an economic downturn are all in place. Is he actually laying the foundations for an austerity budget through this statement? And if so, does it mean he would support further tax rises to ensure the economy remains stable? And where might he propose to focus his efforts should this be the position?
Minister.
Thank you, sir. That's a very interesting question, one that I slightly balked at. It hadn't occurred to me at any point whilst writing the statement that it had anything to do with austerity budgets or anything like that. Not at all. What this statement is saying is that we have a tax rate in Jersey, a standard tax rate of 20%. Personally, I believe that that's appropriate for an island of our size. If we were to follow major nations where you're taxing at kind of 40% rates, I think it would be devastating for our economy. So I think 20% is an appropriate tax rate. It's encouraging to businesses, it gives them reasons to be here, it gives people reasons to live here. At the moment, in terms of taxation, the cost of living in Jersey is in itself significant. That's causing pressures, discussing yesterday with the hoteliers, that's causing pressures in the hospitality sector as prices rise and we're competing against other tourist destinations which are significantly less expensive than Jersey. So increasing taxation would only put greater problems into those sorts of sectors and make Jersey a much less attractive place. So I definitely do not argue for increasing taxation, but at the same time, no member in this assembly should take this statement as an argument for an austerity budget. That was absolutely not in my mind at any point while writing this.
Deputy Joseph.
Sir, thank you, sir. Sir, the statement has a hopeful vision of a thriving, sustainable economy by 2040. Yet, as the Minister has just said, but there's no reference to it in his statement, islanders are grappling with everyday goods, groceries, fuel, utilities, we still have a situation where there is a minimum of a 30% differential between UK prices and Jersey prices. The Future Economy programme speaks of productivity gains and diversification, but where is his bold plan? Does he have one? Does he think there should be one to deal with Jersey's basically punishing costs of increasing inflation?
Minister.
So I thank the Deputy for his question. And I mean, one of the first things that is important to state is that the incredibly high inflation rates that we saw of 2022 have passed through. When I say passed through, they have obviously imprinted themselves on pricing in Jersey. But the inflation rate now is significantly lower. That's very important. But that does not mean that the cost of living difficulties have disappeared. I do chair, as the Social Security Minister mentioned earlier today, I do chair the cost of living group. There is no easy answer to the cost of living in Jersey. We have specific elements of the island, such as having to import the vast majority of goods to the island, which mean that we are at the end of supply chains. And when those supply chains take inflation from the countries they come from, we receive that inflation. And this was part of the rationale behind the increase in the minimum wage, that does help islanders who are struggling with the cost of living. It does help by increasing wages throughout the wage spectrum. But that in itself can feed inflation, so it's a very delicate balance, and one that there is no easy answer to. Obviously, we have seen reductions in the price of housing units in the island over the past couple of years. That has also helped with the cost of living and is due to government policy, because some of that is due to the increase in stamp duty for investment properties. That has helped islanders who are searching for homes have a greater market to themselves without investors competing. But at the same time, it's had a negative impact on the construction sector. So there is no single easy answer to any aspect of the cost of living. It is about taking steps that are considered, thoroughly considered, because every step we take in any direction will have impacts, and some of those impacts can be less than expected.
The 15 minutes for questions, understanding orders has expired, but...
So may I make a
proposition
to extend it under 68(3)A by a further 15 minutes?
Are members content to extend by 15 minutes? I have another 5 members listed to ask questions. Do you wish to ask a supplementary question, Deputy Joseph?
Yes, sir. I don't accept, but it's not for me to point out. The Minister does he not regret not actually putting in this statement, and would he come forward with a series of measures that are possible to deal with the cost of living increases? He speaks about inflation as if it's an imported problem. He knows, sir, I think, that the issue is of the domestic inflation. That's a rate of inflation that is baked in higher than that. And does he not actually think that the competitiveness of Jersey, all the good things that are in this report, is going to be undermined if we continue to have a domestic, which means a higher rate of inflation in Jersey, and which is now baked in? The Minister's not doing anything about it, JCRA or anything else. Does he not think that actually that's going to undermine our long-term competitiveness? And does he not think that we should have a debate, or at least a conversation, about what to do with domestic inflation?
Minister.
Thanks, sir. I have to refer to my previous answer, sir, which is that there are no easy answers to the cost of living matters in Jersey. I wasn't saying that the only element of inflation is imported, but an enormous part of inflation in Jersey, or the cost of living, is imported. That's a fact. It's simple. There is domestic inflation. That is one of the reasons why I prevailed upon the JCRA for many years to undertake a review into the construction sector, which they have done the first part of, but it will only be the first part. I spend a considerable amount of time speaking with the JCRA and encouraging them to use their competition powers to address matters of the cost of living in Jersey. But we have to recognise some of the realities about life on a small island, where we have one industry that is a high pay, or a number of industries that are high paying, but obviously there are other industries which are less high paying. That in itself creates a dichotomy that is difficult, because you have drivers of inflation on the one hand, which are lifting prices elsewhere. I really think the hospitality sector is one where you can truly see the difficulties that the cost of living create in Jersey, because you can see it in their pricing to people outside. So I will continue to work with my colleagues on the cost of living. I do apologise that it wasn't in this, wasn't mentioned here, but the Future Economy programme does talk about the cost of living, and the delivery framework does as well. Thank you, sir.
Deputy Kovacs.
Thank you, sir. Does the Minister agree that in a high-cost economy like ours and global recruitment market, ensuring fair pay and access to a genuine living wage is essential for Jersey to remain competitive and attract and retain key workers and working-age islanders?
Minister.
I think an important element of people's ability to live here is their wages. But as I said in the previous answer, it's really important to always balance any increase in wage against the increase in inflation, because it is very simple. As you increase wages, the cost of living increases too. And so you mustn't drive one and therefore drive the other as well. So it's step by step.
Supplementary.
Yes, mentioning the global recruitment market, what assessment has the Minister made of the UK's recent visa changes, and how might they affect Jersey's ability to attract the skills not available here that our economy and public services need?
Thank you, sir. I must admit I'm not entirely au fait with all the UK changes, but what I will say is quite simply, since Brexit, since the UK's decision to leave the European Union, Jersey has been placed with significant difficulties in attracting people to work in this island. That in itself has helped increase the cost of living, or likely to have increased the cost of living, because people have had to pay more to attract them here to deal with the unnecessary bureaucracy and restrictions that have been placed on people coming to live in Jersey by UK's decision.
Deputy Alex Curtis.
Thank you, sir. The Minister lists three ranges of initiatives in his first page, all of which seem to require the public to engage, and likewise a programme to engage back with the public. So what techniques or ways is the Minister planning on making sure the Future Economy programme is modern or future-looking in its way of engagement with the public, and not necessarily using the most traditional of methods?
Minister.
Thank you, sir. That is a very, very interesting question, because I think one of the difficulties government has, and the States Assembly has as well, is communication with the public. I think it's very difficult, and I think all of us will have realised at different times in our political lives how you feel like something's been said, surely everybody knows this, but then you discover that actually many, many people still haven't heard what was being said. So I don't have answers, but what I will say is that I think it is incumbent on the government to ensure that it uses as many means necessary to communicate sufficiently with different sectors of the public. We know, for instance, that young people communicate in a very different way to the way I would communicate. And equally, we also know, I know from personal experience, as I get older and my eyes change, because they clearly are changing, it becomes more and more difficult to sit there looking at the screen all the time. So I kind of find myself reverting to paper. And I think that's something that tends to happen as well. So I think it is incumbent on government and the communications experts in government to find ways to communicate with people across all sectors of the population. That would include in different languages as well.
A quick supplementary, sir. The Future Economy programme website, with no disregard to the team's effort, could perhaps be a little more snazzy. So will the Minister consider how the content as well, not just whether it's put on a social media platform, but the way of actually reporting and gathering feedback is considered to be maybe more interactive than currently, which is at the moment just an email address, and often through typical methods like consultations which have a start and an end date? Will he consider that as part of the next review?
Thanks, sir. Again, very interesting. I'm more than happy to ask the team to consider that. I would also add a suggestion for the whole of government. The government website needs entire review because it is not user-friendly.
Can I start with St Lawrence?
Will the Minister please expand on his comment that he will be ensuring a greater focus on economic factors in planning decisions? Where is he going with that?
Minister.
I thank the Connoisseur for her question. Sir, it's not so much where I am going with it as where we already are with it, sir. We, a brief piece of context, the 2022 Bridging Island Plan, almost no economic element was included in that. As a result, we now have a shortage of land in Jersey for economic use. My understanding is that the Economy Department wasn't particularly well consulted during that period of time. So what we have undertaken as a department is to engage with the planning department to say, you have to look at economic matters. So when you were being asked about a change of use from office or retail to residential or another use, you must engage with us, or please engage with us as the economy department to understand our take on that. What are the economic impacts of that change of use? What are the economic impacts of building, or for instance, what are the economic impacts of not allowing rural economy businesses to develop outside of St Helier? You know, that's been baked in, as I understand it, to the Bridging Island Plan. It's horrendous, the impact on that, because it means that rural economy businesses find it really difficult to grow and expand. So there is no hidden agenda here, sir. It is that the Bridging Island Plan subordinated economic matters to a dangerous extent. And we have been working, I'm very pleased that the Planning Minister has been receptive to this. We have been working to ensure that the Economy Department and the views of the Economy Department are taken into account when appropriate planning applications are made.
Supplementary?
Yes, thank you, sir. I find those comments very interesting. I'm not going to say whether I agree or disagree with them. But the Minister mentions that there will be an action plan. Will the action plan be from his department or from the Planning Environment Department, or will it be a joint project? And who will lead on it?
Minister.
That is a good question. I'd have to get confirmation. I've always seen it as a joint piece of work. But at the end of the day, it is the planning, the way the planning department and its processes are undertaken is for the planning department. And so in that sense, I do see the final outcome being kind of led, because many of the actions will be for the planning department. But at the same time, the economy department is definitely pushing in terms of saying we need to be listened to and we need to be heard. Not listened to, but heard.
Deputy Gardner.
Thank you, sir. I followed the comments about the cannabis industry. I would like to, currently, we have cultivation of the crop on the island, and island is exported and packaged in the UK, Portugal, and other jurisdictions. So basically, Jersey doesn't have finished medical cannabis product in Jersey. Would the minister consider that Jersey economy actually losing from not having the proper finished medical products and only rely on the agricultural crop? And what can be done?
Minister.
I thank the Deputy for her question. It's a very relevant question. I'm pleased to say that my department is working with the Health Department precisely to work on that issue, because it is correct that the greater value in medicinal cannabis products is derived from the finished medicinal cannabis products as opposed to the kind of commodity plant. And so we are working with the Health Department to and the businesses in the industry to try to move the island and the relevant regulations into a position whereby manufacturing of finished products can take place in the island as well, because that's where the greater level of value is.
Supplementary?
Yes. And how quick this work ministers envisage will progress, and would we see changes in the regulatory framework within this term?
Minister.
I'd have to say I'd have to get back to the Deputy on that. I don't know if there's a specific timeline, but I do know that the Economy Department is engaged to the level that we are supporting staff in the Health Department to help us with that work.
Deputy War.
Thank you, sir. The issue, and I'm pleased to follow up on Deputy Kovac's commentary around labour and labour costs. One of the biggest issues for us is actually access to labour. I am very conscious the Social Security Minister believes we have a very buoyant labour market, whereas we actually struggle to find anybody. So what cost-effective policy changes does the Minister believe need to be made to improve access to labour, particularly in the hospitality industry?
Minister.
Thank you, sir. I speak with slight trepidation in the sense that a lot of our problems with access to labour, as I mentioned earlier, are created as a result of the UK's decision to leave the European Union, and we still obviously sit within the UK's kind of visa policy sector. Any ability to access some labour from Europe, or to make it easier for people who have moved to Jersey to go through the visa process, but equally to have work permits which perhaps don't require 3 years off for 3 years on the island, would help a great deal, I believe. But I do appreciate that not all of these suggestions are in the power or in the gift of ministers in Jersey. Many of them are outside of Jersey, and that means lobbying, speaking to the United Kingdom to get our message across, in the hope that we may be able to come to some sort of accommodation.
Supplementary? Deputy Joseph.
So we've spoken, the Minister's spoken about the importance of employment land, competition, and we've heard earlier today some prorocation about the fuel farm. Bringing those three things together, sir, has the Minister considered in his future economy strategy actually ending the fuel farm in order to allow employment land to be created at La Collette too? Land is in short supply, said Mark Twain once. They're not building it anymore. We've got some. Is the Minister serious about getting more employment land down at La Collette? If so, will he actually lobby the Chief Minister to deal with the fuel farm?
Minister.
Thanks, sir. The Future Economy Programme doesn't speak, I don't believe, directly to the fuel farm, but I believe in terms of land, it is one of our most precious resources in Jersey. It's one of our most scarce resources in Jersey. And so it is important that we always consider the options available to us in terms of facilities on the island and their relation to the use of land. I don't have a specific view on the fuel farm, sir.
So if, supplementary, sir, just in brief, so if the Minister, I don't know whether the Council Ministers have considered this, but there is an alternative fuel farm. It's the use of the existing JC tanks, which came up over 25 years ago. If that could be used for kerosene and the island's non-flammable liquids, then wouldn't he actually think that that would be a good economic prospect, that we could have lots more employment down at La Collette, and we can deal with Jersey Gas at the same time?
You've got 9 seconds, Minister.
I don't know the subject well enough. I defer to the Deputy's knowledge on this subject, sir.
Thank you, Minister. That concludes the period of questions in relation to your statement. Now move on to public business, and the first item is road traffic offences and penalties, P23, lodged by Deputy Catherine Curtis. The main respondent is the Minister for Infrastructure. Deputy Curtis, you have lodged an amendment. Do you wish to take the proposition as amended?
Yes, please.
Are members content for the proposition to be taken as amended? Thank you very much. I invite the greffier to read the proposition as amended.
The States are asked to decide whether they are of opinion to request to the Minister for Infrastructure, having consulted relevant stakeholders, to create an offence under the Road Traffic Jersey Law 1956 for failing to stop and report an accident and to provide assistance to any injured persons following a serious or fatal injury, with the maximum penalty for such an offence to include, but not limited to, a lifetime driving disqualification, and to bring any necessary legislation to implement such offence before the Assembly.
Yes, Deputy Curtis.
Thank you, sir. Firstly, if I explain the amendment, having discussed the original proposition with the Infrastructure Minister and his team, and having sought appropriate advice, I was pleased to add the amendment that relevant stakeholders would be consulted, and to add the word maximum to penalties to allow appropriate discretion to remain with the courts. I also studied the Road Traffic Jersey Law 1956 more carefully, and noted that there was no requirement in the law to provide assistance to any injured persons. So that's included in the amended proposition. I think we would all recognise that it would be a basic human response to assist a person who had just been injured in a collision, whether by calling 999, by giving first aid, or by flagging down help, and that this should be included in the law. So these amendments refine the original proposition. Now, if I move on to the main premise of this proposition, it's not about punishment. It's principally about safety and justice. Dangerous driving, especially when it results in serious injury or death, and not stopping and not assisting any injured persons, shows a reckless disregard for public safety. Allowing someone who has demonstrated such behaviour to drive again could pose a threat to others on the road. If an individual has already shown a willingness to endanger others, they may be more likely to repeat dangerous driving behaviours, making it essential to keep them off the road permanently to reduce the risk of further harm. The possibility of a lifetime ban can also act as a serious deterrent to dangerous driving and a serious deterrent to failing to stop and report an accident and failing to assist an injured person. As for justice, a lifetime driving ban acts as a form of justice, particularly for the victims and their families, and it sends a clear message that those who cause harm through negligence or recklessness cannot escape the consequences of their actions. A lifetime ban also reflects society's commitment to ensuring that individuals who cause harm in such an extreme manner face significant consequences that align with the gravity of their actions. No family or close friends of a victim of a serious road traffic collision should have to see the perpetrator driving a vehicle at a future date. Which brings me to my personal reasons for bringing this proposition. There have been terrible tragedies on our roads in the last few years. We had the deaths of Dean Lowe and his son Charlie. This should never have happened. Like many people, I knew Dean. I worked for the Jersey Employment Trust some years ago, doing an evening job supervising the team of office cleaners. Dean was also a great friend of my ex-husband's. Dean was a big character with plenty more to offer to life. That he should have his life cut short and that of his little boys due to the carelessness and callousness of another person is inexcusable. Since drafting this proposition, I've also spoken to people who've had a family member injured in hit-and-run collisions. I have been so fortunate to have never been in that position, but I have had the awful experience of my daughter being seriously injured in a riding accident. The feeling of being called to the hospital, seeing your child cut and bruised with broken bones is shocking, and that shock never goes away. It always stays with you. And if these injuries had been caused by a careless driver who had left my child at the side of the road to die, I would never want that person to drive again. As for those people who have been left at the side of a road to die, but survived, they face a difficult journey of recovery requiring strength and resilience. They may have permanent, life-affecting injuries. They will have post-traumatic stress and difficulties in managing day to day, either for a period of time or for the rest of their lives. We must consider victims and their families more, and we must do more to prevent dangerous and irresponsible behaviour on the roads. Jersey has the highest road casualty rate in Britain, and it's not okay for us to do nothing about this. Again and again, I hear people saying that there is a huge discrepancy in sentencing of those who undertake road crime in comparison to other violent crimes. If a person killed another by shooting them, if entirely accidental, but then walked away leaving that person to die, we would not give them back another gun licence. And yet we are willing to allow those who cause death of another person on the road and who then leave them to die to drive again. Now, I do understand that a driver, having been in a collision, might well panic. And it's understandable if that driver just doesn't know what to do. But any responsible human would stop and check on the person and offer any necessary assistance. Driving is not a right, it is a privilege. And if a person does not have the ability to drive in a responsible manner, and there is proof of that, then they shouldn't be driving at all. That is why my proposition asks for a lifetime driving ban. However, I do understand the need for rehabilitation. But this must be balanced with the potential future danger that that person may pose, and it must be balanced with the need for justice. I also recognise that appropriate discretion must remain with the courts, which is why the amendment asks for a maximum lifetime driving ban. But through bringing this amended proposition, if it is supported by states members, I expect the courts will recognise the will for more serious sentencing and penalties. A recent petition asked for an increase in sentencing for causing death by dangerous driving. When that petition reached 1,000 signatures, the Home Affairs Minister responded to say that at that time she could not commit to an increase in sentencing. The collision and casualty reduction plan was still being drafted. But the Minister did respond with this, and I quote, "I can confirm that I would support a review of sentencing for these offences to ensure that they are acting as an effective deterrent to those who would commit offences on our roads and to provide justice for road victims." This response to the petition was in August last year. I thank the petitioner for bringing this because it got me thinking. I wanted to see if I could do something to help prevent more serious collisions and to bring more justice to victims and their families. So I started to do research and then began drafting the proposition earlier this year. Because there is a need for this, there is public support for this, and because it is our role as states members, as elected representatives of the public, to bring legislation, that is one of our primary duties. I'm very grateful to the Infrastructure Minister for his assistance with this proposition. Since it was published, I've received many messages of support from members of the public. I believe there is a will to do something positive in response to the awful tragedies that occur far too often on our roads. And I ask members to support the amended proposition.
Sir, can I ask a question of the Solicitor General?
For that, is the proposition seconded? Yes. Thank you. Yes, you may ask a question.
So it's just a question of interpretation, just to clarify something in the amended proposition. To create an offence under the Road Traffic Jersey law for failing to stop and report an accident and to provide assistance to any injured persons, can the Solicitor General confirm whether the offence would apply only to somebody who had caused an accident and failed to provide assistance, or would it occur, according to the wording of this, for anybody, even in the vicinity, who was not involved in causing the accident, to be part of, to have committed an offence if they did not provide assistance?
Mr. Solicitor, yes.
Well, it remains to be seen how the offence is formulated, but the proposition is made in the context of an existing offence under the law, which is an offence that can only be committed by the driver of a vehicle which occasions injury to another. I assume, and if it comes to involvement from the law officers, the advice will be that it must be the driver who's caused the injury who fails to provide the assistance. I hope that's helpful.
Thank you. Yes, Minister.
Thank you, sir. So I wish to begin my remarks by recognising the origins and the intent of this proposition from Deputy Catherine Curtis. The proposition is rooted in tragic events that we're all aware of and that we wish hadn't have happened and that we never wish to see again. This is therefore, and quite understandably, an emotional subject for everyone. The proposition seeks to ensure that we learn as best we can from these past tragedies, and it aims to shape our legislation in a way that makes it less likely that they will happen again in the future. Further, if such events do occur, the proposition seeks to ensure that we don't see a repeat of examples of previous behaviour, if I may say reprehensible behaviour, from some individuals involved. And if such behaviour were to be repeated or to be considered by an individual, the proposition seeks to ensure that the penalties for such actions serve either as a deterrent or a more suitable punishment. Deputy Curtis has been clear with me from the outset as to her objective and motives in lodging the proposition. They are, in my view, entirely proper and good motives. I completely understand the Deputy's thinking and rationale. I've been supportive of her objectives from the outset, and my aim has always been to make the proposition work. This proposition, in its intent, aligns clearly with our collision and casualty reduction plan, which seeks a 50% reduction in the next 10 years in those killed or seriously injured on our roads. That will require action. Some of that action will involve incentives and encouraging good behaviour, but another aspect is ensuring proper deterrents are in place and that poor behaviour is appropriately dealt with. We have committed to a review of legislation in the plan, and I'm very happy for this proposition to form part of that work. I'm grateful to Deputy Curtis for her engagement in recent weeks since this proposition was lodged. She has been open in her communication with us and very easy to work with. We've had some hurdles to overcome, but we've overcome them jointly, for which I'm most grateful, and I'd also extend my gratitude to the officers who have worked with us. The amendment which Deputy Curtis has lodged includes the request that I made and which she has accommodated. I am therefore supportive of the proposition as amended, which I believe sets a path towards some meaningful and worthwhile change. I won't repeat the contents of the comment paper which I've presented, which sets out some of the issues and challenges that we needed to overcome and have overcome in respect to this proposition. As the comments state, an existing offence of failing to stop and report an incident is included in Article 52 of the Road Traffic Law, and the penalty for such an offence is also set out with a driving disqualification of 2 years for a first offence and 3 years for a second offence, committed within 10 years of the first offence. These are sentencing guidelines, and of course, a court retains the discretion to disqualify a person for longer should it see that as appropriate. I also note at this stage the provision in Article 52 for a maximum of 6 months imprisonment where a person fails to stop and report an incident. That is something we can consider as part of this work as to whether that maximum sentence for this offence is appropriate. The issue, though, sir, was that the original proposition wasn't necessarily asking us to create an offence that wasn't already provided for in the law, and this caused us difficulty. We understood the intent, but Deputy Curtis needed to amend the emphasis of the proposition to ensure that we were being requested to enact tangible change. The amendment has dealt with this issue as it adds in a potential provision for an offence of the failure to provide assistance to any injured persons, something which doesn't exist in the law at present. And if we think of past incidents, the act of failing to provide assistance is a key behaviour which was unfortunately and tragically lacking. Of course, we would rather these incidents on our roads didn't occur at all, and that people behaved responsibly, including complying with the requirement to stop and report an incident. Adding to the law a requirement to offer assistance to injured persons following an incident with associated penalties for failure to do so, and reviewing the custodial sentence for failing to stop, in my view, starts to develop the law in a meaningful way, to act as a greater deterrent and to hopefully shape people's future actions in a more positive way. I believe that is what Deputy Curtis has now achieved in her proposition as amended. So I'm also aware of some concern around the provision of a lifetime disqualification. I don't wish to tread on the territory of sentencing guidelines and the discretion and independence of the courts. I recognise that human rights considerations and the need for rehabilitation to always be an option. That is why the amendment now recognises that this would be a maximum, not a mandatory penalty. But we should also recognise that there will still be some cases where rehabilitation isn't evident or where a crime is so appalling that a lifetime ban is appropriate. This proposition sends a signal in that respect, and, as I said in the comment, I will write to the bailiff as Chief Justice requesting him to consider a review of sentencing guidelines in this respect to take place alongside the legislative work. In her amendment, Deputy Curtis also includes a requirement for consultation. This is important because these proposed changes, whilst in my view worthwhile, will need careful consideration and implementation. We need to consider whether to integrate the proposed new offence into the existing law or to create a specific separate offence. We need to consider some other related legislative changes, one of which I have referenced regarding the custodial sentence for failing to stop and report. We need to engage with the courts and with legal professionals as well as the community. We may well need to raise public awareness through campaigns, and we need to ensure that what we create is enforceable, proportionate, and that it works. As always, the best outcome will be the one which is delivered collectively. Sir, if a proposition is lodged which fundamentally aligns with the Minister's policy objectives, then I believe a Minister should do everything they can to work with that proposition, and this is what I've sought to do. If we get this right, I believe the outcome will be an improved legislative framework which provides greater protection for road users. This encourages people to act properly following an incident and acts as a further deterrent for those who don't. The easy choice is to do nothing, but that is not an option for Jersey with our record of road safety. This is a proposition which seeks to learn from the past and to make improvements for the future. I'm grateful to Deputy Curtis, and I ask members to support the proposition as amended to allow this important work to proceed. Thank you, sir.
Thank you, Minister. Does any other member speak on the proposition? Deputy Balash.
So the question put by Deputy Renouf at the start of this debate underlines, I think, the desirability of bringing forward propositions of this kind in consultation with the Law Officers Department, because the law relating to road traffic is complicated. And it was interesting that the Minister's comments reveal that he had not previously been aware that it was already an offence not to stop and report an accident. I agree with Deputy Curtis that failing to stop and report an accident where someone has been injured, perhaps fatally, is a particularly amoral and nasty offence. And I can sympathise with the view that a lifetime driving disqualification might sometimes be appropriate. But I am glad that the Deputy has amended her proposition to leave the discretion with the court as to whether such a penalty should be imposed, because I would not otherwise have supported it. And I hope that the Minister, in writing to the bailiff in connection with any sentencing guidance, will also recognise that it is important to acknowledge that circumstances differ from case to case, and that it is extremely important not to tie the hands of the court so that an injustice might inadvertently be caused. So what is the effect of the amended proposition? As I say, it's already an offence to fail to stop and report an accident if there is an injury to any person. What is added, or is proposed to be added by this proposition, is a requirement, and I quote, to provide assistance to any injured person following a serious or fatal injury. Whether that is practical will, of course, depend upon the circumstances of the case, and this may give the legislative drafter some headaches in framing an appropriate form of words. But I certainly agree that providing assistance is what any decent person should do. Whether the injury must be serious or fatal before the duty to assist comes into force is perhaps open to doubt. Any injury surely requires a person to offer assistance if he or she has been the cause of it, but that no doubt can be something to be ironed out by the legislative drafter in due course.
Thank you, Deputy. Deputy Taddier.
So during such debates, I think it's important that not only the mover of the proposition and the minister or ministers in charge of the legislation or that area of responsibility speak, but that the Assembly gives its wider considerations about the spirit of the law that's being passed, not least because on occasions courts can look to the intent behind legislation that is brought forward, perhaps in its interpretation, sir. That's my understanding. And I think we do well to remind ourselves that these are not just theoretical eventualities that might or might not play out, that there are tangible examples that we know about in our community, sir. Sir, I have been, I suppose, watching recently, it seems, and I'm not sure for what reason, but maybe more than usual, reality programmes about crime and punishment. There's been one on quite recently, which members may have seen, called You Be the Judge. It featured recently, I think last week, on Channel 5, and it's You Be the Judge, Crime and Punishment with Anne Robinson. And it reviews, it takes a number of case studies from cases throughout the UK, some of which involve manslaughter, for example, others which might involve climate activists, and it compares the sentences that were handed down in such cases, and it asks people what they think about them. And what's quite clear, not least because you have to add in the UK's creaking prison system into that, is that there are very few satisfied people sitting on the armchairs, especially when it comes to the families of victims who may have lost their lives. And I think we do well to remind ourselves that actually so often in these high-profile cases, it's the names of the perpetrators which get all the publicity, but often the names of the victims are forgotten, not in all cases, but in some cases that is the case. And we know that only recently in Jersey there was a case, and many of us knew the family involved, and I think it's important that we do put a face to the names and actually say that, you know, I'm thinking primarily when I look at this hole in the legislation as I currently see it, something that Deputy Catherine Curtis has identified. I'm very much thinking of somebody that I knew who was called Dean. Many of us might know of him, but Dean Lowe, who I counted as a friend, some of us knew him from the music circuit or whatever, and I knew of young Charlie as well. And so when I think about the proportionality of somebody who has killed somebody and left the scene of the crime, somebody who's made a conscious decision to get into a vehicle, a car, a van, which is a potential murder weapon or certainly a potential weapon in the wrong hands, and that person then goes on to take 2 innocent lives, but also doesn't stop at the scene of the crime, drives off, and then I know where I feel the proportionality should be in that. And I very much see, so these are not easy things to say, of course, but I think sometimes this is the place to say them during such a debate, that, of course, the Minister will want to talk about rehabilitation and the fact that this shouldn't be an automatic lifetime ban. What I would say is that when that individual or a individual comes out of prison, having been released, possibly having been rehabilitated, but not necessarily, that individual, of course, will still be free to lead their lives. They'll be free to do many things, and it might be that they go back to work, that they can still go to the same pub that they drank at before, and I think the very least is that they shouldn't be able to get back into a vehicle. I think that's not too much to ask. And I think the very strong message from this Assembly should be that Certainly in a case where there's been a fatal accident, which has then been gone on to be proven, so it's no longer an alleged that you killed somebody or a number of people with your vehicle, and you fail to stop, and you fail to report the incident, I would hope very much that whilst there would be sentencing guidelines, it would pretty much be automatically the case that certainly when it involved a fatal accident, that person would never be able to get behind a wheel legally again. I think that should already be the case. It's not. It's been identified by Deputy Curtis, and I think we should overwhelmingly support this. The question I would ask here is where failing to stop and report an accident leads to the death of somebody. I think that is certainly something which should automatically follow, sir, for a lifetime disqualification.
Thank you, Deputy. Does any other member speak on the proposition? Deputy Joseph.
So I would just, I know nobody else wants to speak, and I would just like to thank the Deputy for bringing forward this amendment and having the courage to actually bring this to public attention. I think that the comments that have been made about overly prescriptive have been taken on board by the Deputy, and I think that she should be proud that she's brought this forward, and we can actually, overall, I certainly will be supporting the Deputy. I know other members will as well, but she deserves our thanks to bring something to matter to the Assembly in the right way, in a constructive way. Thank you, sir.
Thank you, Deputy. I call upon Deputy Curtis to reply. Deputy Curtis.
Thank you, sir. And thank you to all the members who have contributed. I won't go over their comments because this is very emotional. My thanks also go to campaigners for change. And I was encouraged to read through the collision and casualty reduction plan that has a lot of, it's a very good report actually. I'm hopeful that this proposition could help to achieve some of the aims of that plan. Just briefly, the plan includes the aim to work towards Vision Zero, and that is a road safety philosophy that originated in Sweden, based on the principle that no loss of life or serious injury on the road is acceptable. It assumes that while human errors are inevitable, they should not result in fatalities or severe injuries. So I don't think I need to say more, except that if members support this proposition, I hope it will bring some comfort to victims, their friends and families. I hope it will encourage safer and more responsible driving. And I call for the appel.
The appel has been called for. I invite members to return to their seats. I ask the greffier to open the voting. All members have the chance of casting their votes. I ask the greffier to close the voting. I can announce that the proposition has been adopted unanimously, 47 votes for. The next item is the draft Electoral Registers Jersey Amendment Law, lodged by the Chair of the Privileges and Procedures Committee. The main respondent is the Chair of the Corporate Services Scrutiny Panel. I'll ask the greffier to read the citation.
Draft Electoral Registers Jersey Amendment Law 2000, a law to amend the Elections Jersey Law 2002 in relation to electoral registers and for connected purposes, the states, subject to the sanction of His Most Excellent Majesty in Council, have adopted the following law.
Chair.
Thank you, sir. I'm delighted to say that the changes proposed today by PPC will create an automatic voter registration system, replacing the current paper-based process with a database created from the People Directory, a database which draws upon interactions with Revenue Jersey in relation to social security matters. as an employee or claimant of a benefit or pension, for example. The register of names and addresses and information held by SIPES for those still in full-time education aged over 16. PPC believes that this system will be more accurate than the existing system, which accepts people's statements on trust and is not verified by the parishes. The system will also better reflect the position closer to the election date, rather than using data gathered over 6 months earlier. The proposed system will allow for a more recent sweep of the data, taking account of change, such as people leaving the island or passing away. The reasons for making these changes are to make it easier for people to vote automatically, including anyone who is entitled on the base electoral register, increase the democracy of our electoral process by removing barriers to voting. The main changes within the legislation are removal of the individual's duty to make a declaration of entitlement, removal of public access to the register. Instead of the public having to complete an annual statement to confirm the names of those who live in their home who are eligible to be on the electoral register, those who have been ordinarily resident in Jersey for the last 2 years, or have been ordinarily resident in Jersey for the past 6 months, but have a cumulative residency of 5 years or more, people will be included automatically on the register if they are over 16 and meet the relevant residency criteria. The existing system allows islanders to apply for their name to be omitted from the register if they are concerned that there is a risk or threat of personal harm to themselves or someone who resides with them, if their name and address details were to be made public. As the electorate will not be able to opt out of this system, it is only right that public access to the register is removed. In the new system, the register will only be available to electoral administrators and the judicial grefg, with a copy provided to the archive on an annual basis as a historic record. Candidates for elections will be provided with a list of properties which fall within their constituency, rather than names and addresses of individuals. The rationale for this change is to respect personal data, protect the public's right to anonymity, and avoid any adverse impact on those who might feel less safe, such as survivors of domestic violence. The new register will include people who may have previously made a conscious decision not to make a return, either because they had no interest in voting or did not wish to be included on the list for jury duty. It is estimated that only 60% of statement forms are returned to parishes. By increasing the accuracy of the register, we expect that there will be an increase in the total number of people included. And I should note that it's people's civic duty to be on the register for jury duty. Islanders will be able to check online to confirm that they're on the register using a specific self-verification app, which we are developing. If they are not, they can seek to be included by approaching their electoral administrator, provided that residency can be proven. The electoral administrator, the parish secretaries, will still have a residual power to add a person to or remove a person from the register. The number of potential voters needing to be added in this manner is expected to be minimal, but there will be a dedicated app which people can use to check their registration status. The system will be able to identify future voters, those who will be turning 16 on election day, or who will have met residency criteria on that date. Again, communication is key, and VoteJE will target messaging to those who have moved to the island in the last 2 years, reminding them of the need to check they are included, where appropriate, on the register. A supplementary register will be available up to 7 working days before the election, and this will accommodate islanders who move home in that period. Anyone who appears at the polling station on the day of the election, but not on the register, will be able to be added to the register by the electoral administrator if they have supporting documentation. The electoral administrators in each parish will retain overall responsibility for the register. Although there is a risk that a more inclusive electoral register will see fewer people voting percentage-wise, PPC is hopeful that the opposite will happen. We believe that those who might have been unsure that they were eligible to take part will be encouraged that we value their voice and can be inspired to participate. Through VoteJE, The GREF will run a dedicated communications campaign explaining the changes, highlighting that people may now be eligible who previously may not have thought that they could participate, and everyone will be encouraged to exercise their democratic right and use their vote. I urge members to support the principles. Thank you, sir.
Thank you, Chair. Are the principles seconded?
Yes, sir.
Does any member speak on the principles?
So may I ask a question of the SG?
Yes, you may.
So I was just wondering, part of the this change is about data being held by particular individuals or particular representatives of the organisation. Can I ask the SG what the consequences are for breaking data protection law in Jersey or GDPR, and perhaps even an explanation of the difference between the two, so that we're clear as to what that means if you are a data holder in Jersey? Thank you, sir.
Yes, Solicitor.
Well, the data protection law, I haven't turned it up, but provides a general rider that where data is provided pursuant to statute, it is not, as it were, within the purview of the data protection law. In other words, sharing data for a statutory purpose is perfectly permissible. So I don't see a problem in this draft with data that is held by certain agencies being required to be presented to an electoral register.
So I thank the Solicitor General. I think my question was not worded as clearly as it could have been. I understand that. If you are that data holder that is provided with this information, what is the consequences if that data holder breached that holding of data, i.e. gave that information to somebody they should not? Is that a clearer question? Thank you, sir.
Again, without turning up the data protection law, I think the answer is to be found there, which is that there are either sanctions or criminal sanctions of misusing data.
Thank you, sir. And just one further question, if I may. If an individual became a holder of that data, i.e. somebody running for election, it was extended to somebody running for election and you had to sign a data agreement to hold that data, would those same rules apply to that individual of potential criminality later on in the process? Just to be clear, because it's a question that's running through my head. Thank you, sir.
Yes.
Well, unless you're holding data in an absolute personal capacity, for example, my knowledge of my son's activities, then you are a data controller for the purposes of the data protection law. My view is that politicians who come into possession of data of that sort are data controllers within the meaning of the law.
Sorry, sir, I do have another question. I've asked the Assembly just to forgive me for all the questions. What I'm asking is, in the run-up to an election, if you are specifically identified as somebody who's standing for election and sign up for that election and become a data holder of that information, I assume that the same rules apply. So if you misuse that data in that capacity, you are committing a possibly criminal offence. Just to be absolutely clear. Thank you, sir.
I take that to be the general principle provided by the data protection law, yes.
Yes. Any more questions for the Solicitor General now? Yes, Deputy Alex Curtis.
Thank you, sir, and apologies for another question to the Solicitor General. In his first response to Deputy Rob Ward, he highlighted the difference between data collected by statute rather than in other mechanisms, and said that that would be governed under the statute and not the Data Protection Jersey law. Could he confirm, we're just on principles, but we'll debate the actual regulations or articles which I believe the mover said would remove the power for candidates to be data controllers. Is he suggesting that in a different world in which that article wasn't removed, if a statute allowed candidates to be data controllers under statute, they would have legitimate right to such personal information because the collection of that data was under statute, and therefore there would be a world in which, notwithstanding politicians may have concerns now setting the law, there is a legitimate route in a form of law that would allow candidates to have that data.
Well, the data protection law provides a general caveat that data which is processed pursuant to a statutory obligation, it doesn't fall within the ordinary purview of the data protection law. I wasn't aware that this provides some other provision. I'll have to have a look in the course of the debate and second reading if I'm asked. But generally, the principle is the one I've stated. If you're processing data for a statutory purpose, then that is a caveat carve out from the data protection principles, provided you are complying with the principle.
Yes, Deputy Scott, you've got a question for the Solicitor?
Yes, for the Solicitor General. Could the Solicitor General please just clarify with Article 26(9) of the law says that nothing in that article authorises the authority to order a public authority other than one falling only within paragraph K of the definition to pay a fine. So just if he could perhaps clarify whether actually the public authorities that are covered by this amendment would be required to pay a fine.
I'm not sure which article the Deputy is referring to.
To which law are you referring when you refer to Article 26(9)?
The Data Protection Authority, Jersey Law 2018, sir. Sorry.
Yes.
26.
Can I just have a look at that? Can I have a moment? Could I also ask the Deputy just to repeat the question because I'm not sure I followed it?
Yes, could you possibly repeat the question and the Solicitor will have a think about it? And
I just asked if he would confirm, once he's looked at that provision, whether the advice is given about public authorities paying fines actually, whether to just confirm that in the context of that provision. So that's 26(9) of the Data Protection Authority, Jersey Law 2018. Authority, yeah. Thank you.
Yes, Deputy Joseph, your light was on first. Do you want to?
Thank you, sir. Can I first of all thank the chair of PPC. There's no other opportunity to say it. However, on Friday we're talking about democracy in registers, and on Friday we celebrated with our hearts ablaze. We celebrated our 80th year of liberation, a freedom won before courage, democracy, and this is what this debate is about. And may I just say, because this is the only opportunity, how absolutely fabulous it was to hear the chair of PPC speaking in Liberation Square on our Liberation Day, sir. She really was on form, and she really did a brilliant job. And I think that, I don't need to say any more, sir, because other people haven't said it, but I've said it, so I've got through that. Sir, I understand and absolutely agree with what the chair and the committee is doing. We have had an archaic and a problematic issue with electoral registers. I've always been concerned that the actual real voter turnout that we have in our island is actually far worse than the statistics give us because of, as the chair so rightly says, there have been such a paucity of some parishes better than others, some more difficult than others. That's not to criticise, but in fact having an automatic data registration system is undoubtedly the right thing. Islanders not having to opt in, residency rules, all the rest of it. It's certainly a digital spring in the step of democracy. And that's got to be good from St Helier to St Wands, whether there's a deputorial or a senatorial election. The vote is a seed of liberty, said a poet, sir. I just wonder, however, one question, this is not a question, I don't think the Solicitor General needs to answer this because it's a political question. I note that the new electoral register is going to be shielded from public view for candidates. And I just wondered whether or not, as the UK doesn't have that provision, Canada doesn't have it, we are not going to be out of step with other jurisdictions in actually not allowing the electoral register. Democracy is a precious thing. I understand the privacy issues, but really, is it absolutely necessary for us to agree the article that prohibits effectively from public view the electoral register? But I don't underestimate the problem is, and I thank again the chair for what she's doing for us.
Thank you. Deputy Scott, your light was on. Do you want to speak now or for a question?
Yes, I'm happy to speak now, please, sir.
Yes.
Yes, I just wanted to thank the Privileged Procedures Committee for the work that they've done on this. I just had a couple of questions that I would be grateful if the Chair could address in her closing speech. Given that the law, the changes extend to election dispute resolution and that the JEA would be offering a public service in that respect, I wondered if she could just perhaps confirm that the intention of the PPC is to ensure that there will be publication by the Jersey Electoral Authority of its complaints handling process. If the committee has discussed or will discuss the support to be given to them in this respect, and also whether they will be publishing a procedure to enable the review of any decisions by the JEA and by whom. Thank you very much.
Thank you, Deputy. Deputy Balash.
Sir, may I, first of all, endorse the remarks made by Deputy Ozef about the Chair's speech on Liberation Day. And I'm sorry to have to follow that up by saying that I don't find her reasons for bringing forward this projet de loi very persuasive. The reasons for making the changes, according to the PPC's report, are to make it easier for people to vote by automatically including individuals, and increasing the democracy of our electoral process by removing barriers to voting. It seems to me that there are no barriers to voting. If people want to vote, there is absolutely no barrier that prevents a person who wishes to vote from voting. And so far as making it easier for people to vote, I think the same comment applies. I'm not sure why we are wanting to make this change. The Comité des Connetables point out very correctly that there is a real risk that the turnout figure will drop unless more choose to cast their votes. And it seems to me pretty obvious that the percentage level of voter participation will be worse than what it was before the enactment of this law. At 42%, we are already close to the bottom, if not at the bottom, of the OECD table. Why do we want to diminish Jersey's reputation even more by putting us in an even worse position? Another unfortunate consequence of the proposition, and Deputy Ozef referred to this, is, as the PPC explains at page 3 of its report, that the register will become, in effect, a secret document to which candidates for election will not have access. Candidates will no longer be allowed to know the names and addresses of voters. If canvassing, candidates will have to knock on doors without having any idea who is behind that door, nor even whether the person who answers the door actually has a vote. One of the small courtesies of canvassing is the ability for candidates to address voters by name, and that will go. And that seems to me to be a great pity. I can see only one justification for artificially expanding the register by automatic voter registration, and That is the introduction of compulsory voting. If we had compulsory voting, if we were to move to compulsory voting, as in Australia, it would obviously be important to know who the voters were, so as to ensure that people who were entitled to vote were on the register. Otherwise, enforceability would be very difficult. But there is no indication from PPC that they are contemplating compulsory voting, and I'm going to assume that that is not in prospect at the moment. If there is no compulsory voting, what is the point of forcing people onto a register if they don't wish to vote? You can take a horse to water, but you cannot make it drink. In my view, and I'm sure most members will share this view, people should vote. It's a civic duty to participate in the voting process. But people also have a democratic right not to vote if they choose not to do so. It seems to me that the efforts of PPC should be concentrating not on swelling the register in this way, but in trying to establish exactly why it is that people don't vote and addressing those causes. There are numerous causes, and I think we know many of them for what they are. We have a large number of people who work in the financial services industry who are here perhaps for only a relatively short time and who can find no wish to engage in the process. There are many from minority communities that take a long time to adjust to being in a foreign country and to getting used to the idea of what voting in this democracy means and involves. It's not difficult to register to vote in our elections. It's a very simple form which any person can fill out, and huge efforts are made by the state's GREF, the Electoral Authority, and indeed the parishes to encourage people to register and to take part in the electoral process. In summary, sir, I don't believe that automatic voter registration will encourage people to vote, and I think that the disadvantages of the scheme outweigh the advantages.
Thank you, Deputy. Deputy Mezek.
Thank you, sir. And I, of course, align myself completely with everything that Deputy Joseph said in his speech, not just about the proposition itself, but of course about the Constable's speech on Liberation Day, which I have to say was the best I've heard in my time as a States member. I align myself, I think, perhaps with maybe about 10% of what Deputy Balash said, and I'll come to that as I elaborate on that. But if I could start, I think, on that by saying that I do disagree with him when he suggests that there are no blockages in order for somebody to be able to vote. Bureaucracy, by its very nature, is a blockage. There are ordinary people out there in our society who are not as engaged in politics day to day as some of us might be, and who may wish to vote, but are simply not as familiar with the mechanics of it as the rest of us. And I find it time and time again on the doorstep that I meet people who say they didn't realise they needed to register to vote. They thought, well, I'm on the rates list, isn't that the same thing? Like, just people for completely innocent reasons don't know. So, sir, in this instance, I support the good conservative principle of reducing red tape, which is why I wholly endorse the principle of this law. and introducing automatic voter registration, I am 100% behind that. It's long overdue and something that we ought to wholeheartedly support. The idea that it will reduce voter turnout, I don't think is really true, because though it's currently the case that voter turnout statistics are published on the basis of turnout of registered electorate, you can ask for data on turnout of eligible electorate, which is normally one of the first written questions I lodge after an election, because turnout of eligible electorate is a much more useful figure than turnout of registered voters. It tends to bump it down by about 10% when you get that. So I don't really think it's actually that interesting what it will do to the statistics, as we can get them under the current system anyway. And so I will absolutely wholeheartedly vote in favour of the principles of this law. But I align myself with everything Deputy Ozif said about some of the mechanics of this, and in fact some of what Deputy Balash said, and say that I think the structure that is proposed in Article 12 is a grave mistake. I think that it is written from a perspective that doesn't really get the realities of how you run an election campaign, how you as candidates seek to build rapport with voters on the doorstep, and how you as a participant in democracy try to get turnout up as you would go around your districts canvassing with people. So there are all sorts of uses that having a copy of the electoral register as you're canvassing has. First, it's the icebreaker of being able to say, oh, was that Mr. and Mrs. So-and-so? And if there's something not accurate, you pick it up and you can go to the authorities and say there might be a mistake here. You can say to people as you knock on the door, oh, I have other people registered to vote here. That might be your children who are eligible. And you can help spread the word, which is really important. But on top of that, sir, is a crucial issue that I don't think has been well addressed in this, which is the ability that it gives candidates to safeguard themselves and know when not to go canvassing and what addresses to avoid. So I'll say this because it's not a very nice thing to have to say, but it is the truth, sir, which is that candidates and politicians, among some very small number of people out there in our community, do face harassment and abuse, some of which reaches thresholds that are extremely serious. So I myself have had to go to the police about members of the public who have spoken in such a way that make me think that they pose a viable threat to me. I know of other politicians who have faced racist abuse, misogynistic abuse, and though, of course, there is no perfect safeguard against all of that, at least we know when we're outdoor knocking, if you see a name that you recognise of someone you shouldn't be going anywhere near, you can avoid doing so. So I have nightmares of the idea of one person who I'm thinking in particular, who I do not want to send candidates out to go knocking on their door because I think they'll be in danger if they do so, and being armed with the knowledge of knowing who it is you're going out there to knock on their door enables you to take action to protect yourself. And it's a normal thing that happens in other jurisdictions. So I've written to the chair of PPC last week to outline some of my concerns about these. I got responses back from the greffier on this, but in her opening speech, the chair didn't indicate how she might want to proceed on that basis. My recommendation to her is that she should not proceed with the debate on Article 12, but instead should pause that, do a bit more consultation with members, and then we can hopefully enthusiastically get behind it when it comes back to the Assembly in a better thought out way that we can have greater confidence in. She didn't address that in her opening speech. I hope she'll reference it in her closing speech, and I hope it won't be taken that though I have grave concerns about Article 12, it won't in the least bit stop me from voting for the principles of this law, because they in principle are a good thing for democratic engagement and for assisting people in accessing the vote without going through the bureaucratic process of registering that they did before. But one particular element of this could do with a bit of thought, and I'd like to know how the chair intends to proceed with that. And I reserve my right to then take a position in the debate on the articles if it's not satisfactory.
Thank you, Deputy Alex Curtis.
Thank you, sir, and I don't know whether to thank or to be frustrated by Deputy Mesic for taking what I would have said. So this will be far shorter, but I would like to address likewise a few of the points made by previous speakers. Like Deputy Mesic, I fall perhaps between Deputy Joseph and Deputy Balash. I think the debate on the voter turnout is one that continually frustrates me. I think Deputy Balash said those who have a right to vote, which is many, have a right and they can choose to exercise it. And as such, if our voter turnout is low, that is what it is. And I think we deal with the nuance within the systems rather than what it is often felt like, which is up the number. We will know, as we hear anyway, we'll be able to compare eligible voters to those who voted, and that won't change. I really put my light on to address that of the public register. It feels like, to use a phrase, maybe a sledgehammer to crack a nut. In one fell swoop, we are not only taking away public access to the register, but we're also taking away access to those who I remember signing quite solemnly a data controlling agreement as a candidate to destroy the register after having it. It was Article 9 in the elections law, I believe, that provides the right for someone to remove their name and be anonymised. Not only is that being deleted, Article 11 is being deleted to provide the public access in the first place. And Deputy Mesic said that Article 12 is being largely substituted. And I was going to call for exactly the same request consideration before we move too far into second reading, particularly around what can be done. It sounds like, as we are setting out data use within statute, that if we are to allow those who are standing to have access to data for a purpose, it wouldn't seem a far stretch to extend Article 12, Part 4B, make available free of charge to the candidates a list of all residential addresses and occupants. Registered eligible occupants may well be something. And before we get too deep into the weeds of each article, maybe in her summing up has said, the mover will be able to deal with whether we can defer the second reading or consider how we can best address that, because I can support the principle, but likewise I would rather see a solution which enables that access to those who have to discharge their duty under the rules they sign up to, which is to destroy it and not to use it for purposes outside of the election. So I don't see what the reason for withdrawing that was, and I think the slight ruse of data protection is a little excessive. Thank you, sir.
Thank you, Deputy. Deputy Miles.
Thank you, sir. There was a couple of things that I wanted to mention, but members have already mentioned the concerns around Article 12 that I share. And particularly as a woman, and quite often as a lone woman who was going around the parishes knocking on doors, I would quite like to know who is likely to be behind that door, rather than knowing that people have addresses, and particularly in this day and age where we're very conscious about violence against women and girls, etc. So I think I just wanted to raise that issue. The other issue that I wanted to raise that I don't think has been mentioned so far is, to my mind, this isn't just about automatic voter registration, it's about automatic jury registration. And that is something that is concerning me, and I don't know whether the question should be for the Solicitor General or whether it's something that the Chair of PPC can follow up. But certainly it's my understanding that under the Criminal Procedure Law of 2018, eligibility for jury service says he or she is entitled to have his or her name included on the electoral register in accordance with Article 5 of the Public Elections Law. We are now in fact compelling people to have their name on the public elections register. That is my understanding. We do know, not necessarily evidentially, but certainly anecdotally, that people say that they don't register to vote because they absolutely do not want to be a member of the jury. Yes, of course, being a member of the jury is a civic duty, as is the requirement to vote. But actually also in that 2018 law, there are a very limited number of exemptions and a very limited number of disqualifications for people who would serve on a jury. So although we don't know evidentially, I would suspect that actually the tirage, the jury list might expand exponentially, and there will be people who absolutely do not want to take part in a jury and who have no grounds for either exemption or disqualification. So I would like perhaps the chair of PPC to address that. Thank you.
Thank you. Deputy Renouf.
Yes, sir. Thanks. Thank you very much. It's been a real education, actually, in this debate for me. Real education, actually, an unconscious bias in a strange way. Because I must admit, I have never worried about who is behind the door when I've gone and knocked on somebody's door. And perhaps that reflects the different threats and different risks that people face without even having any sort of conscious thought about that. It may just be a lack of imagination on my part as well. And it also reveals that I realise how amateurish I am at campaigning, because I didn't go around with the electoral roll looking at names before I knocked on doors. I just knocked on doors and hoped for the best. But I do want to take issue with Deputy Balash's comment where he said there was no barrier to voting. And I did want to expand a little bit on this, because I do think this is an important point. There are barriers to voting, I think, connected to the electoral roll. I suspect in Deputy Balash's quite well-ordered world, and again I may be making an incorrect assumption here, people do know well in advance that they want to vote. They always fill in forms, and they know they have to register, and they know how to do it. But I don't think that is the situation for many people in our community. People may only decide late that they wish to vote. They may, who knows, be so excited by talking to you as a candidate that they decide they do want to vote and aren't able because they're not on the register. They may have thought that someone else in their family had registered for them, and actually they hadn't. They may have moved house recently and not have remembered to inform the authorities. So I think that that we should be trying to make the process of voting as friction-free as possible. And an automatic voter register does that. And the idea of being forced onto the electoral roll implies some kind of compulsion on people. And I think it is simply an automatic enrolment, and there isn't much sign of compulsion in the sense of forcing someone. The only other point, I think, is around this question of turnout. The turnout figure doesn't change because we change the percentage calculation. The same number of people will have voted, and they represent the same percentage of our population. You can calculate that in any way you want, but the underlying reality does not change. And we can't say that just for marketing purposes. We'd rather change the calculation basis so that we don't look quite as bad internationally. The figure is the figure. We should face up to it. And I think the electoral roll is a good way of being much more impartial about that calculation and removing ambiguity around it. I've listened very much to these concerns around Article 12, and I shall listen very carefully to what the Chair of PPC has to say on that matter. But in terms of the principles of this, I have absolutely no doubt I can support it.
Thank you. Deputy Rob Ward.
Thank you, sir. I had a list of things to say, and I crossed off most of them because of previous speakers. But there's a couple of things I will mention. I fully support the principles of automatic voter registration. I share the concerns over Article 12, so I won't go into them again. Although I will say I don't think it's impossible to make candidates a data controller so they're under the same laws as everybody else and they face the same sanctions should they misuse the register, so that's something we can do. I would actually like to reiterate the importance of knowing who's behind that door for candidates. I did mention I had violence against women and girls on my list. Deputy Miles quite rightly mentioned it. I would say that I do share concerns regards who's behind doors, particularly when you're going to
lots and lots of flats and you're very isolated from elsewhere when you're knocking on doors, and I think it is very important for safety reasons for us to know who's there. But I want to mention a couple of other things. First of all, we have a very progressive system here where you can vote at 16. And of course, I would say as Education Minister, I suppose it's important that our young people are educated in voting and being told you are automatically registered. There is nothing for you to do apart from the importance of voting. And we all, I think most people in this Assembly have been to schools to talk about the importance of that from across the Assembly, and that's such an important thing to do. So I'm a bit of an election geek. I've been to observe quite a few elections now, and one of the things that stayed with me was I had the interesting experience of observing US elections, and one of the things they did, and it was in Boston's main town hall, was every time a new voter, somebody voting for the first time, arrived to vote, the entire hall applauded. And I actually found it quite an emotional experience standing there. And what are they doing? They're voting. And there was a real interest in why you vote and what you're doing. So there are subtleties that we need to build into our electoral system to encourage people to vote in that way. And I think the automatic voter registration is a key part of that. So the rest of it is for the later in the articles. But I will also say there's one other issue, which is by knowing names, you can advise on where people vote as well, because I think too frequently, well, when I say too frequently, even if it happens once or twice, if somebody goes to a polling station, they're in the wrong place, but they can't be bothered to go to another one for whatever reason, because they think it's the end of the day, I have to pick my family up, I have to be at work. There are many reasons. We should not be removing the franchise from people to vote because of that reason. So they need to be very, very informed as to where they're going to vote as well. And I believe this will help. So I support this wholeheartedly. When we come to the articles, there is obviously a growing issue with Article 12, but I think that is something that is solvable. So I think we can move this forward, and I urge people, members to support the principles in this. Thank you, sir.
Thank you, Deputy. Deputy Taddeo.
Thank you, sir. Sir, I agree with many of the comments that have been made. The first thing to address, I suppose, in the principles is whether or not the principles are sound and whether or not we, or more specifically I, can vote for them. And I do have some concerns. I understand why changes are being made. So let's start off with the automatic voter registration. That's really the essence of this proposal. I think it is right because with some experience, I think PPC have listened to the frustration that has been expressed to members more generally and candidates more generally from members of the public saying, why do we have to keep registering? We've already registered once. We've lived in this house for 20 years, or we registered 2 years ago. Why are we having to fill in a new form? So anything that makes the process automatic, if you like, so that they don't have to fill in new paperwork, that should be a good thing, so long as it's I think proportionate. I think there's also been a lot of misunderstanding about whether or not registration is obligatory. I've been told this morning that it's not obligatory. You don't have to. It's not a legal requirement to register to vote, but I think you do need to often return your rates form, and the two seem to be linked in many cases. I'm not sure if that's always the case, but people do get fed up of having to fill in forms and send them back. So it's this idea of government saying, tell us once, and the parish is saying, tell us once, and I think the parishes in many ways lead by example when it comes to the automation of information. So I think that's got to be a good thing on balance. There is a question that's been raised, valid question from Deputy Balash, should there be an opt-out system? I don't know if that's the case, because if we think about it, whilst the primary purpose of an electoral roll, it goes without saying, is for election purposes, there are consequential potential obligations that arise from that which you can circumvent by not being on the register. So I don't know if it's been mentioned already, sorry if it has, but jury service, of course, is selected by those who are on the electoral roll. And if you're not on the electoral roll for whatever reason, then you haven't got a full pool of people to choose from for the electoral roll. And it may well be that there are certain demographics, for whatever reason, that don't find their way onto the electoral roll or fall off the automatic or the roll more often than others. And I would suggest that happens more frequently in urban areas, and it happens in areas where people move around a lot as well. And certainly they shouldn't be in some way expunged from both the duty and the responsibility of being on a jury. And similarly, for those who maybe avail themselves of the purpose of a jury when facing trial. But those are not the primary considerations, of course, that we're talking about today. But I am concerned, and I'll make this other point first before I get on to the concerns I have. And I would tend to agree, we shouldn't be fixated on the percentage and what it looks like. What we should be actually making sure is that anybody who currently doesn't vote, who wants to vote, and who hasn't found themselves on the register, actually, if you can get 10 people on the register who wouldn't have been on the register and who vote for the first time and continue to vote, that's got to be a good thing in absolute terms. So we should be concerned about absolute numbers, not percentage numbers and perceptions. Of course, we should be making sure that when we benchmark ourselves with the international community, we're looking at making sure that the benchmarks are correct and that's a level playing field. So the analogy I would use is that we should be looking to grow the cake of people who vote, and it's better to get 45% of a 1,000 gram cake than to get 48% of a 900 gram cake. I'll let members do the math, so to speak. Now, the reason I've got concerns about the principles is that, for what I can see, is that it's not clear to me whether the principles hang on the articles that are going to be moved, or whether there's a mood within this assembly to actually kick out or even refer back some of the articles. And in fact, if there is a reference back, which I understand there may well be, on the deletion of Article 11, then should it be now or should it be when we get to that article? Because I believe that there's a non sequitur that PPC has followed here by saying that we need an automatic registration system and therefore you can't opt out. We're not going to let anybody see the electoral roll. It seems to me that at least part of the purpose, and not an insignificant part of the purpose of having an electoral roll, is so that candidates at an election time can see who is on the electoral roll. And that has been the case for as long as I can remember. And to remove it without any consultation, it only clicked to me that this was happening at our parliamentary meeting yesterday. You could argue that I should have read this before. But I think many members were in the same position, that they hadn't realised, or they hadn't realised the potential significance of it. And it leads me to think of a potential, I don't know whether to call it Kafka-esque situation or Python-esque situations that candidates could find themselves in when they're knocking on doors. Because I've certainly knocked on a few number of doors in my time, not just in St. Brelard, I hasten to add. And actually, we have to remember that from the constituents' point of view, they're not living and breathing elections. They don't necessarily know whether they're registered. They don't know if they've been registered in the right place. So the number of times I've knocked on a door or spoken to people in their yards and they said, oh no, I'm not registered to vote. And I say, aren't you? Okay, well, why not? Well, let me just check the roll for you. Is this your name? Yes, that's us. Okay, so it appears that you are registered to vote. I said, oh, well, that's great. We didn't think we were registered to vote. Secretly, oh, damn, we did. We wanted to try and get rid of Deputy Tadia, but he now knows that we vote. so we just have to be polite from now on. I'm not sure. It's not, sir. I'm sure it's not. But the constituents are not always parliamentary in their language, sir.
I think you must edit their comments to you accordingly.
Yeah.
Referring to them.
That's another fine mess they've gotten me into. So I take that, and so I do withdraw that particular word. And so actually, there is, I think Deputy Balash had a nice turn of phrase for it. It's that there's something personal about being a politeness, I think he called it, about being able to go up to somebody and address their name. And of course, we might know some people's names, so I might knock on a particular door and say, hello, Dennis, hello, Joan, hello, Sue, hello, Charlie, how are you doing today? Don't worry, it's fine, we've got all the literature, we're going to vote, don't worry about it. New candidates don't have that option, you know, so we might be looking at this from our point of view. Similarly, somebody might forget a particular name, or you might think, oh, I know that face, I don't know who they are. But I think primarily that candidates, whether incumbent ones or new ones, are also there to give a kind of signposting. So you're not just there to sell your manifesto to somebody, but you're actually there to give practical information, especially if you're in a district like ours where you might have more than one polling station, and you say to people, actually, they say to you, I'm not sure where I go to vote. Well, you're still in this district, so you need to vote down in St Albans, you need to vote at Communicare, etc. Even if they don't end up voting for you, you're able to be really helpful, I think, as a candidate. And I think this would be one of the unintended consequences of the deletion of Article 11, would be that kind of purpose would be removed. And I think it's disproportionate, because I do hear the arguments about what happens if somebody doesn't want to be on the register, but that's already taken care of. We've got a register which is public. We've also got a register where people can put their names on a secret register, if you like, so that it's not available, and there will be good reasons why those individuals don't want to be on the register. And we could have a crazy situation where, you know, a credit agency, I've been having conversations with the Minister for Finance, both now and in the past, and we know that credit agencies in Jersey want to have access to the electoral roll, and that people want to be on the electoral roll in some cases so that they can have a good credit rating. So you can have a very bizarre situation where credit rating agencies are able to know who's on the electoral roll, but candidates for an election are not able to know who's on an electoral roll. And that, I would suggest, is where the Kafkaesque bit comes into it. Absolute madness that should be the situation. So I don't feel that I can vote for the principles knowing that actually all of these bits hang together collectively and that they haven't been thought through properly, I don't think, in terms of the unintended consequences. I fully believe that actually we should be going in a direction where we open up the electoral roll much more, because you've got a strange situation where the constables, because of the nature of their job, do have access to the electoral roll. They need to know who ratepayers are. They and their staff at least need to know that if somebody turns up to a rates assembly, a parish assembly, they know who's allowed to vote and who's not allowed to vote. I would suggest that actually politicians, civil society groups, when they're trying to hold their own meetings, should be able to go around and canvass, not just at election time, but actually all times during the year on different issues which might be important. And that is something which is enjoyed by politicians and activists throughout the world, so in many countries. And I would like to ask PPC to actually look to be going in the opposite direction, not to be closing down access to the electoral roll, because that may be taking us in a completely opposite direction to what they're intending to do in terms of engagement and wider democracy.
So may I raise a point of order?
Yes.
Thank you, sir. So a number of members have raised the issue of whether or not they're going to vote for the principles of this bill. Am I correct in, and would you rule, sir, whether or not we can vote in favour of the principles of it, but then ask PPC to do a line-by-line with other members clarification of the actual articles, that we don't have to carry on with the articles today if we don't wish?
Yes, you can. Under Article 73, once the principles have been adopted, Standing Order 73, once the principles have been adopted, it's possible for the Assembly to determine to continue the debate, so postpone discussion of the articles for up to 2 meetings. So you could effectively postpone the articles being considered until the end of June to give consideration to the matters you've just referred.
Yeah. I'm grateful, sir. Thank you.
Yes. Deputy Catherine Curtis.
Thank you,
Point
sir.
of order?
Yes, it was just, point of order or clarification. I'd just like to assure the Assembly that I've listened to everything that's been said, so I'd really like to have the principles voted on today, and would like to defer the articles and bring the articles back amended where possible to address these concerns no later than 24th of June. Thank you, sir.
Yes, Deputy Catherine Curtis.
I will just speak briefly then. I just wanted to give the example around concerns of Article 12, I think it is. During the last elections, a certain individual posted on social media that if I should knock on his door, he would, and I can't remember the exact words, but there was a threat of violence. Needless to say, he wouldn't welcome me to his door. I've never met this man, but I knew his name.
and this was a threat that had to be taken seriously. The police went to speak to him. Candidates who are women or of a different ethnic background will be placed at risk because, unfortunately, there is hatred to us just because of what we are. I need to know whose door I'll be knocking on to be able to stay safe. And honestly, if I don't know who's behind the door I'm about to knock on, I don't know if it's safe for me to actively take part in the election process.
Deputy Curtis. Deputy Luce.
Thank you, sir, and I've got very little to add, and I'd like to address a very serious point made by Deputy Catherine Curtis there, but in a very much more light-hearted way, and in furthering the speech by Deputy Taddy about non-parliamentary language. A certain afternoon in St Martin is etched on my memory when our door opened and the person who opened it said to me, and I paraphrase, "You've got a jolly nerve showing your face at my house." And that is a great paraphrase. I knew what was coming, sir. I knew what was coming, I knew the name, and I was prepared, but I think it's really important to know beforehand. If you are getting into difficulty, you can stand back, take 10 seconds and just think about how you're going to address things. I'm not one for not knocking on doors, and I've been to a number of places where I've been advised I shouldn't go on my own, but I have. But finally, I'll just address, Deputy Balash mentioned manners, and I think it's very important. The first thing I do when I open it, good afternoon, Mr. and Mrs. or whoever, and the name. And of course, it's also important to know if there's more than 1, 2, 3, 5, 6 people living in a property, and they all might vote. And I'm grateful to my constable for saying what she has done about taking the articles back. Thank you, sir.
Thank you. Deputy Doublé.
Thank you, sir. I fully support the Chair's intention to come back with the articles, and I'm sure we will give, on PPC, will give serious consideration to what members have raised. I just wanted to touch on barriers because Deputy Balash, the thing that made me want to rise to speak was he said there are no barriers to voting, and I think many members' speeches have addressed this. And we've spoken about perhaps more vulnerable or protected characteristics that might make people more vulnerable to harm. Those characteristics also introduce barriers to voting in the population. So where somebody may have caring responsibilities, disabilities, they could be a victim of domestic abuse and not able to access their own mail to register. They could be an elderly person suffering with arthritis. There are many barriers to actually just the step of registering. So this today is really important to remove just one of those barriers. But I think we've all also experienced being at polling stations and people turning up thinking that they can vote at the polling station that we're at and having to turn them away. And sometimes that has happened right at the end of the day. And this person has, and I think as Deputy Balash said, if you want to vote, you'll make the effort. Some people really do. You know, they make that effort and they come out to a polling station. And sometimes they're devastated that they're turned away because they can't vote at that polling station. And a poll that was done, not a poll, sorry, a survey as part of the Joel survey last year, when islanders were asked what some solutions were to increasing their participation. And the second most popular solution was being able to vote at any polling station. And what we're doing today, and hopefully we'll complete when we bring the articles back, is the step towards allowing that. So we can't have voting at any polling station if we don't have this automatic voter registration. It's the step towards that. So I have been told. Before I sit down, so I wanted to talk about safeguarding of candidates, and I think it's actually really important that we've had so much discussion on this today, and I'm really pleased that we're airing these issues because they are becoming more and more relevant. And certainly, I've been through 3 elections, and it's increasingly becoming a little bit more of an issue, isn't it? That political rhetoric. There are some more extreme views out there, and as I think Deputy Curtis said, there there is hatred out there that can be directed towards candidates. And we must take that seriously. And we must, first of all, be role models and conduct our debates with respect for one another, which I think this debate today has been. But we also must put in measures to safeguard. And I think when the articles come back, I'm not sure whether the chair or indeed the committee will decide to change that Article 12 so that we do have the names of the people whose houses the doors we're knocking on. But either way, I would say that the GREF could perhaps consider a register whereby if somebody has made threats against a previous candidate or a states member, it would actually be quite helpful to inform candidates that those threats have occurred and where that person is. Because if you're a brand new candidate and you're not part of a party, even if you know that person's name, you might not know that actually they're a potential danger to you. So even having the name of who's behind that door might not be enough. So that's something I would like PPC to consider when we discuss this. Again, final point I want to make, and it's about Deputy Renouf and his speech. And this is not the first time I've noted this about Deputy Renouf, and I think other members are getting there and kind of on that journey. But what a great ally Deputy Renouf is, because what he did today was he reflected on the fact that he wasn't aware that these problems were a problem for some candidates and members that are different from him and aren't like him. And he raised that lack of awareness, and I think that's very powerful. And I think that reflection on what is essentially, that's what privilege is, when you don't have those barriers and you don't have those problems that some categories of people do. Being able to bring that out into the light, to reflect on it, and I think and I hope from Deputy Renouf's example that he is a great ally and that he will work to try and support those who do face those barriers. I just think that was very powerful, and I wanted to thank Deputy Renouf for that and to encourage other members to reflect in the same way.
Thank you, Deputy. Deputy Morel.
Thank you, sir. And before I get going, I'm just wondering if you would mind taking a look, sir, at Standing Orders 72.2, just to see whether under that or any other standing order, it might be possible to ask for the proposal to be referred to scrutiny. And the reason, sir, I feel, is that I've been quite surprised at what I would say seem to be oversights by PPC. And to me, it seems that a fresh set of eyes would be a very good idea. And in that sense, I think scrutiny could play a good role of having a completely fresh set of eyes looking at this legislation, having heard this debate. It has surprised me that PPC had thought it would be okay for us to go knocking on doors and candidates to go knocking on doors without knowing the names and addresses of the people behind that. I think we've certainly heard the safeguarding issues, and I'd have thought that would have been primary in PPC's mind as a body. Apparently, it wasn't. But there's also the perspective of the candidates themselves, especially new candidates. But I know that I've undertaken 2 competitive elections, and each of them, the first one even more so, that first door, or those first few doors, it's steal yourself time. It's such a strange thing to do, to go knocking on the doors of strangers. You take away the names of the people behind those doors, and I think particularly for new candidates who have never before stood in an election, it is a massive disincentive to go and knock on those doors. And that's something, given PPC in their report talk about the 40% turning out, that's one of the things that surprises me, because I think you're likely to get fewer candidates as a result of that element of this, and that in itself is likely to make the electorate less likely to turn out. I won't repeat many of the same concerns that have been mentioned already, but I would like to say as well that I am still actually struggling with the whole concept of automatic registration. And the reason for that is simply that I know people don't like having choice removed from them. And that at its core, really, this is about removing choice. Whilst I know people can ask for their names to be removed, etc., so there is an element of choice, but you're subordinating that to the automation. And I think there will be some members of our society who are quite unhappy at the idea that they've had that choice removed removed from them by this automatic registration. There's a sense of kind of paternalism or maternalism, take your pick, but there's a sense of us telling the electorate what they should do. And I don't feel quite happy with that. So I'm still personally struggling with the actual principles of this. I'm not necessarily against, but I'm just wanted to express that I am still struggling with that removal of choice from electors. One other short thing to Deputy Renough's comment about the 42%, or not to his comment, but he raised the kind of 42% voter turnout. And I am struggling with PPC's continued use of that statistic whenever they bring forward electoral or amendments to the electoral law or changes to the electoral process. Because it suggests every time that somehow this latest change is going to inject a sudden desire amongst the population to vote. I don't think this is ever going to happen. We can fiddle with the electoral process all we like. People are not going to vote as a result of changes of process. Personally, I have a view that one of the reasons we have a low electoral turnout is because many, many people who live in Jersey don't necessarily think of Jersey as their permanent home. It's not the only reason. I've got people born in Jersey, lived all their lives in Jersey who don't vote. I've got friends who don't vote. But I do believe that we do have a large part of the population who have moved to Jersey during their lives, many of whom I think they may have been here for 10 years, but still have that view that they're probably going to move back to where they started, or they'll move on somewhere else, and so haven't really engaged with the political side of life in Jersey. And that really speaks to us and the need for states members, whoever the states members are, to make ourselves relevant to those people and to make ourselves relevant to the people who are born in Jersey, my friends who choose not to vote. That's what will change the electoral turnout, a sense of relevance, a sense of feeling that the choices they make, people make when they come to vote, actually do affect and impact their lives properly. It is our failure to appear relevant to those people that is really suppressing voter turnout, in my view. It wasn't, I mean, I say it wasn't that long ago, it's about half a century ago, which in many views it was quite long ago. But in the 70s and 80s, we still had very healthy voter turnouts, to my understanding. And it really was during the kind of late 1980s that voter turnout fell significantly. That, I believe, is due to that changing nature of Jersey's population and the fact that we have many more people here who don't see the island necessarily as a permanent home. What we want to say to those people is, you may only think you're here for 10 years or 15 years, but it's still relevant and you can still make choices which can improve your lives today. But if you choose to end up living here for the rest of your lives, those choices that you make when you vote will have an impact on you. So I really wish PPC would stop pretending that changing the electoral process is going to make any significant difference to voting in this island, because I truly think it won't. And it is wrong to keep meddling with the system and believing that meddling is going to make a difference. We are the ones who will make ourselves relevant to voters. We are the ones who will make voters or the electorate turn out to vote, not anything to do with the process. So back to the 72-2, sir.
Well, that's correct. Of course, Deputy Morel, in any event, if the principles are adopted, in the first instance, the draft law will be offered to scrutiny, and only if they decline to scrutinise the matter will the Assembly nonetheless have the power to postpone consideration of the articles in the way that I've described.
Sir?
Yes.
I wonder if I may invoke 79(1) of the standing orders.
You're proposing that the debate be suspended for the purpose of scrutiny. Yes. Well, this will be debated now, won't it? Yes. Well, under Standing Order 79, a member is entitled to propose without notice that the debate be suspended for the purpose of scrutiny. 79 says any member of the States may propose without notice that the debate on any proposition be suspended, and the States request the relevant scrutiny panel, relevant review panel to consider having the proposition referred to it. And that's the proposition that you make. Is it seconded?
Yes, sir.
Does any member wish to speak on the proposition that the debate be suspended for the purpose of scrutiny?
So will the proposer be making a proposal as to why she wants to do that, why it's a good idea?
Yes. Do you want to make the proposition, please, in the first instance?
Sir, I haven't got much to add to what Deputy Morel said, which is basically that we are hearing concerns raised by members regarding the changes in terms of Articles 11, 12, regarding the proposal that the electoral register no longer be made public. And it would seem that things like safeguarding issues haven't been discussed with members. It sounds to me as though it would be appropriate to have the scrutiny panel look at it, and rather than us be continuing until we get to the point where the chair of the scrutiny panel is asked whether she would like it referred to the panel, that this would be a time to just accelerate that process so that members can move on to other business and have the scrutiny panel review it in the meantime.
Does any member wish to speak on this matter? Deputy Renouf.
I'll speak against that proposition. I would like to see this matter voted on at the principles stage, and then I think the proper place for scrutiny would be to examine the articles and as appropriate. But I think we've had a good debate on the principles. Some people don't agree with them. That's fine. But we should move to that vote, and that will guide the process that scrutiny will go through. They will have a much clearer sense of a narrower scope of what the work is. So I would vote against this.
So given the response of the States Chamber now, I'll withdraw the proposition then.
Are members content for the Deputy to withdraw a proposition without a vote?
Sir, may I make an interjection? I know Deputy Miles, as chair of the scrutiny panel, would like to speak on this subject before it's withdrawn, sir. Well, may I intervene?
I think we must stick with procedure. You've applied to withdraw, and are members content to let the Deputy withdraw her proposition without a vote?
No, sir. No, sir.
Yes, in that case, it's withdrawn. You're not happy with that?
No, sir. So I'd like
no, sir.
Deputy Miles to speak, sir.
I'm happy to.
Well, the debate must be restricted to whether or not you should withdraw your proposition. Who wishes to speak on the proposal that this proposition should be withdrawn? Yes, Deputy Miles.
Thank you, sir. I've had my light on for a few minutes, but other people have been... I had my light on originally to ask what the procedure was.
It then went off again.
Well, I left it on and I was waiting to be invited to speak. And Deputy Scott kind of jumped the gun, invoking Article 89, because my question really about procedure was that given the comments of the chair of the PPC, I was going to invoke, when you, at the conclusion of the debate on the principles,
yes.
I was going to say that my panel would call this in.
Yeah.
And I wanted to know whether that was acceptable, being that PPC had already said that they were going to take it back.
Well, it's your right to
It is, and that is what I wanted
right.
to clarify. And I think the confusion with Article 79 is that it stops the debate in its tracks.
It does.
And we then don't get an opportunity to hear anybody else who wants to speak and then vote on the principles.
That's correct.
Thank you, sir.
Does any other member to speak on the proposition that Deputy Scott be permitted to withdraw her proposition? Deputy Joseph.
Thank you, sir. I don't know whether you've got a new practice, sir, that it's only people with their lights on that get called. But I just wondered, because I've been putting my light on and off, and I didn't know whether you've put me down or not. Have you got a practice that we need to leave our light on?
No, you were going to speak. I had Deputy Miles, then you.
Okay, fine. Okay,
Yes.
that's fine, because when it doesn't know one.
But we're now talking. But you put your light on in connection with a different debate. We're now dealing with the debate on the proposition that Deputy Scott be permitted to withdraw her proposition under Standing Order 79.
Thank you, sir. I wish to simply ask in this, I don't agree with Deputy Scott's proposal the most orderly way, and I apologise to members if I set the cat amongst the pigeons when I said that I was sowing a seed. I'm sorry about that, but I was not aware. I apologise to other members that I should have read the electoral register issue before, and we didn't, and we deserve our apologies to the chair of PPC, but she's done the magnanimous thing, and she said that she's going to take back the things. But what I would like to ask is, I thought that there were checks and balances in this assembly about issues, and I certainly had some understanding that corporate services actually did scrutinise legislation. We've spoken about legislation scrutiny so many times, and I just wonder whether the chair of PPC could clarify in her concluding remarks whether she did seek it, that this should be scrutinised, because obviously, and I say that in the context of our next election, sir, being on the 7th of June 2026. And there is now a time clock ticking. Where
you're straying beyond the purpose of this very brief debate, is whether or not the Assembly will permit Deputy Scott to withdraw her proposition.
I do agree, sir. I just want to know whether or not we're going to be able to get within the 12-month international standard of basically considering legislation for our electoral arrangements, that we can actually not defy our international standard, which is basically you shouldn't change electoral law 12 months before an election.
Does any other member speak on this proposition? Deputy Tadia.
So, I didn't start this debate, incidentally. There are a suite of options before us, and the starting point that I work from is that we should be in a position, this isn't a criticism because these things happen, and sometimes it's not until something gets to the floor of the Assembly that we realise it's deficient, and this is the case today. What should really happen, I think, is that PPC should be coming back with a proper proposition in all parts that members can vote for. We haven't got that today before us. And I think that in an ideal world, it shouldn't be going to scrutiny at all, sir. It should be going back to the committee that brought it forward in the first place, because we don't have a dog and bark, I would argue, and that PPC is really the last committee of that this Assembly has, and it is a quasi-scrutiny body already. It does that work through a process of consensus with a joint mixed membership. And this is effectively where the scrutiny has happened during this debate. So in the very narrow question as to whether or not Deputy Scott should be allowed to withdraw her proposal to refer this to scrutiny, I think there's a sense in which it's much more preferable that this Assembly should decide whether it wants to refer this to scrutiny rather than scrutiny calling it in against the will of the Assembly. Because I look at my esteemed colleague, who's the chair of not just her scrutiny panel, but of the, well, she's chair of rather the corporate services scrutiny panel, and is very busy. And I wonder how she's going to do that work, which is effectively work that PPC should be doing. So I would like to ask members to consider actually sending a message out that, because the alternative is that this is referred back to PPC at the in principle stage. I think that's probably what needs to be done. They need to present it back to us in a coherent way to see if the articles that they propose are in line with the principles that they're proposing. And that's not something that scrutiny can do for them. So I think, of course, we have to let Deputy Scott withdraw this proposal, but I don't think the consequence of that should be that scrutiny call this in, because it's very unusual, I would suggest, for scrutiny to call in something coming forward from PPC. It's not without precedent necessarily, but scrutiny normally calls in work from ministers, sir. So with that said, by all means, let's let Deputy Scott withdraw this.
Does any other member speak on this proposal? In that case, I close the debate, and those in favour of allowing Deputy Scott to withdraw a proposition kindly show. Was the appel being called for?
Please, sir.
The appel's being called for. Members are invited to return to their seats. This is a proposition to permit Deputy Scott to withdraw her proposal under Standing Order 79 to suspend the debate for the purpose of scrutiny. Those in favour, please vote for, and those against, please vote contra. I ask the greffier to open the voting. All members have had the opportunity of casting their votes. I ask the greffier to close the voting. And the proposition has been adopted. 42 votes for, 3 votes contra, and 1 abstention.
Sir, is it in order for me to ask for this whole thing to be referred back under Standing Order 86 to the committee so that they can come back before we vote on the principles? I firmly believe that unless we know how the principles and the articles hang together and what's going to be presented in the articles, then I certainly can't vote for the principles without knowing what I'm voting for. And I think the right place for the reconsideration to be done is with PPC. That's their job, not to give extra work to scrutiny, who will feel obliged to call this in when they have other, I'm sure, I can't speak for that panel, I'm sure they would do the work, but I'm sure they've got other work that they need to concentrate on, sir. And therefore, PPC will be also be in control of the timetable. The information that I will be seeking in the reference back, sir, would be for clarification specifically around the access to the electoral roll, but perhaps also for consideration about how members of the public who do not want to be on the public list might be able to put themselves on a secret list, or indeed whether an opt-out for them would be indeed appropriate or possible.
Do you mean under Standing Order 83 or 86?
I was looking at 86, sir, but if...
It's 83, which deals principally with reference backs. 86 is a debate after a reference back.
83 then, sir.
And the further information that you seek, just to repeat it so I've got a note.
So it's to see, to find out whether it would be possible for PPC to not delete Article 11 and to have an accessible register for candidates, but also to see if it would be possible for members of the public who don't want to be on the publicly accessible list to be on a secret list, and to consider whether there would be a workable way to allow people to opt out from being on the electoral roll within a process of automatic registration.
So the 3 issues I've written down, Deputy Elliott, are for PPC to clarify its position in relation to access to the electoral roll, to identify if members of the public can put themselves on a private or secret list, and thirdly, to clarify whether members of the public could opt out of being included in the electoral roll. Is that right? All right. Well, the proposal is that the matter be referred back for those purposes.
So,
do you want to? Yes, Deputy
It's a
Morel.
point of order, but it's more about my own ignorance than anything else, sir. I don't quite understand how Deputy Tudyer's proposition can take place after Deputy Scott's proposition.
Hers was rejected. This is a different proposal under a different standing order. Yes, do you wish to speak to the proposition?
Yes, precisely because we have now referred it to scrutiny. I don't understand.
No, the proposal under Standing Order 79 to suspend the debate for the purpose of scrutiny was withdrawn. So we are now currently still debating the principles until now, when we are now considering a reference back under Standing Order 83. Yes, do you want to speak to this proposition, Deputy Sadier?
I think I made the case, sir.
All right. Is it seconded?
Yes, sir.
Does any member to speak on this proposal for a reference back? Deputy Balash.
So I rise only to ask whether the President of PPC might be willing to indicate that she is prepared to accept the reference back, because it is very clear that a number of concerns have been articulated in the Assembly, and there is something for PPC to think about. And Deputy Tadier has put them together in a very composite way in his reference back. And if the chair of PPC were willing to accept it, we could all move on to the next matter for debate.
Deputy Joseph.
So I rise to just do a point of principle. I think that this Assembly is often saying that we don't scrutinise legislation. The proper parliamentary process in other places is that you receive a first, a second and a third reading. The purpose of the first reading is to receive the purpose of the law and then send it to scrutiny. I see no reason, with the greatest respect to the mover of this proposition, for us to do anything else apart from respect our conventions, that we take a vote. That is not a vote which automatically agrees the articles. But members have made their views known, but we have basically had a discussion about whether or not we are, as an Assembly, of the view that we need to have this kind of law. And then the issue now is to look at the articles and them to be properly scrutinised. I don't understand why it hasn't been done, but I think it would be against our working practice for us just to simply throw the thing out at this stage. I do say to members, we do have a lot more electoral law to come. We've got quite a lot of senators' laws to come, one of which is amendment to this very law. And I think it's the right and proper process for us to go and give the chair of PPC the purpose of what we always do, which is to assent to the first reading of it, and then to send it off to scrutiny, which the chair of PPC has already kindly said. The chair of the scrutiny panel that I think should have looked at this before, but maybe they were too busy, but they need to do it. They've said yes. So what's the problem? We go to the principles. We know we need to do this. We should go and respect our parliamentary privilege, our parliamentary tradition, which is a first reading, and then we go to the articles. That's the way I think we should do it, sir, but I may be wrong.
Thank you, Deputy. Deputy Renouf.
Yes, so I agree with Deputy Joseph. Because I think that there are considerable risks here if we refer back on the whole thing to be referred back, which are that we've got a reference back on 3 points. We don't know whether they will actually be exhaustive of all the issues that will need to be considered. Then the risk is that we will come back with the new proposals that address those 3 issues, maybe to some members' satisfaction, maybe not. But then other issues will be raised, and then the opposition possibility of a referral back to scrutiny will arise again. And then we will be into the post-summer recess, post-summer period, and facing a situation where we're making multiple changes to the electoral laws, including senators, right up against the deadlines. And I think that we have had a debate about the principles. The principles some people disagree with, that's fine. They can vote against the principles. But as Deputy Joseph says, we have a debate on first principles, then we move to consider the articles. The way we're going to choose to do that, because the chair of PPC has indicated, of corporate services has indicated what she'll do, we'll call them in and they will be looked at by scrutiny and brought back. And I think that is the proper way to approach this thing, and will mean that we move forward both at a decent speed and with due respect for process.
Deputy Miles.
Thank you, sir. As the chair of the Corporate Services Scrutiny Panel, I would prefer, as Deputy Renouf has said, that we go through to the principals and then our panel gets an opportunity to scrutinise the piece of legislation in its entirety. I would like to say that we have not looked at this at CSSP. I have to say, I don't know why. I think it isn't the normal thing for CSSP to scrutinise. I see a member saying it is. It's nothing that has been put across our table. If it had been, we would have done a thorough job. So if we haven't done the job we should have done, I can only apologise. But certainly, if it comes to a reference back or it comes to debate the vote upon the principles, CSSP will call it in, if that's helpful to members.
Thank you, Deputy. Deputy Alex Curtis.
Thank you, sir. Very quickly, it might be my parliamentary kind of ignorance or lack of understanding, but in agreeing the principles, to what extent are we signalling we agree with the main substance of the report, which included the changes required to legislation are removal of public access to the register, and to what extent are we then agreeing a principle that we know the majority of the Assembly wishes to change? It may be a question to you, so I'm genuinely in your hands. I would like to support. I would like to support the moving beyond the principles and into the review of the articles. But I just want to understand, from a parliamentary position and legislative position, if all of us are agreeing to the principles yet don't largely agree to, for example, the removal of public access to the register, is that considered poor practice?
I'm afraid I can't answer that question. That would be a political question for me to answer.
Point
yes.
of order. Can I make a point of order?
Yes, you can.
Thank you, sir. Are we not, in your ruling, sir, you're not being asked to make a political point, are we not just approving the principles
yes, that's
as
right.
in the opening paragraph? That's all we are approving. We're not approving anything else.
That's right.
So in fact, the deputy's concerns can be assuaged.
Again,
because all it is
a political matter. I don't think I can tell members what they're voting for in terms of the principles. They've heard what's been said by the chair of PPC. The next member to speak in relation to this issue is Deputy Morel.
Thank you, sir. A number of things, actually, and I think picking up from where Deputy Ozef left off, I think one of the problems, and I believe I've had this sort of conversation with Deputy Ozef in the past, the states going first reading, second reading, third reading, all in a half-hour gap sort of thing, is that we have lost all real understanding of what it means when we say the principles. Equally with the third reading, I often feel that we don't have a real understanding of that. The only thing I think most of us would feel comfortable defining would be the articles. We understand that part. And so it was interesting, sir, as you responded to Deputy Ozef's question, that point of order just now. Sir, if I may say, be so bold as to talk about you and the Deputy Greffier. You were nodding whilst Deputy Greffier was shaking his head. And
I can promise you we were in agreement. Not always, but we were that time.
And I felt that really summed up exactly, I think, where we all are in the Assembly about understanding what the principles are when we say we're voting on the principles. I actually understood the reading that Deputy Kirsten said, which was, if you say to the principles, you know, if you ignore the reference back and the three particular points, when you vote on the principles, there would be nothing on PPC to look at elements such as the one that Deputy Curtis raised, because it hasn't been written into the reference back. Because we're no longer working with the reference back. And so I am confused, number one, I'm sure you can tell, but two, I am concerned, because I think there are some serious areas in here that need to be looked at, and if PPC didn't look at them and they came back saying, oh, well, they agreed the principles, we only looked at Article 12 and that was it, you know, I'd be incredibly disappointed in PPC, to tell the truth. I also just quickly wanted to address the issue about PPC and scrutiny. My understanding is PPC's work is rarely scrutinised, if ever, and that's because it's a committee of the Assembly. It has people from government, it has people not in government, and so the idea, I think, somewhat of an idealistic idea, somewhat brought over from the previous pre-ministerial form of the Assembly, was the committee does its own scrutiny. But today I think we've learnt exactly why that doesn't work, sir. one word, and this is deeply unfair of me, but because it's conjecture. But when I kind of was reading through and listening to the objections to the main proposition, I did feel perhaps PPC had suffered from something of groupthink in this respect. And they would just think, yes, we need automatic voter registration. They hadn't really thought through the safeguarding issues and the impact on candidates and things like this. I might be wrong. I might be doing PPC a disservice. That was my speculation. But it shows why I do believe that PPC's work does need to be scrutinised, sir. And I think that would be a useful proposition for future weeks and coming sittings, sir, because I think it is wrong that PPC's work goes unscrutinised. Thank you, sir.
Thank you, Deputy. Chair of PPC.
Thank you. It's just to say, with respect to scrutiny, that I've just checked with the Grefin, as far as we're aware, PPC has never been scrutinised by corporate services. Oh, it has. I've got another. Well. All right, sorry. Oh, sorry, I've just got another message to say. I had one saying it wasn't, but yeah, the Le Fondre panel scrutinised some electoral changes. Yeah, but as the whole time I've been in, since 2018, it has never been scrutinised. I was not aware that we had a scrutiny panel. So, but I'm quite happy to be scrutinised. I'd also like to say to Deputy Morel that we have taken on, we are cross-party. We have all sorts of, we're a very mixed bunch in PPC. And we have taken this really, really seriously, and we have gone through it, you know, quite thoroughly. So yes, I do, and I did say that we would take back Article 12 to look at. But if he sees how long this is, you know, we have not taken it lightly. We have gone through this. And if you see how long the articles are, and really only thankfully only Article 11 and 12 have been mentioned. So yeah, we are quite thorough in PPC. So I'd just like to stand up for my committee. Thank you.
Thank you, Chair. Deputy Scott.
Sir, I feel that somehow things have been a bit shambolic, and part of the problem has been a lack of consistency in the way in which things are done. If we look at this and coming to Deputy Morel's point about the meaning of principles, we have had one example where the PPC has consulted with Assembly members in terms of what they might wish to have, and that's in the case of the amendment of the Code of Conduct following the proposition that I brought in ethics, which I withdrew to give PPC an opportunity to do that work. What's happened here is that the PPC has actually engaged law draftsmen to draft a law that members actually aren't comfortable with. And we do need to learn from this about what exactly has happened to arrive at this point. Perhaps it does make sense that there is more of a process by which PPC brings its propositions, so that perhaps it might consult members beforehand, perhaps it might brief the corporate scrutiny panel, which is allocated the responsibility for scrutinising it after all. Where do we get to here? Well, we have a bit of a kind of weird dilemma, because it sounds like we can refer, if we don't support Deputy Tadier's proposition, if we respect the chair of the corporate scrutiny panel's request that we move on to principles, approve them, and then have the referral to scrutiny. Some of us have a problem with approving all the principles. It therefore would have been helpful, I think, for the chair of the PPC perhaps either to, with consulting the panel during the course of this debate, to withdraw the proposition perhaps, or at least to, and when proposing the principles, or to, unfortunately it's a bit too late, to actually be saying, well, but you know, not this one or that one. I don't even know whether that can be done now. But I don't have any solutions, but I will just point out that members have been left in a very difficult position. If we go to, you know, if we don't approve Deputy Tadier's proposition right now, then we have this difficulty of approving principles that we don't want to approve. Thank you.
Thank you, Deputy.
I wonder whether I might propose the adjournment, sir, so that actually we could leave the chair of PPC with other officers to come back and actually explain, because we're going to have 9 minutes where we might make a mistake, sir. So I'm just politely saying to members, there seems to be some confusion. À tête reposée, overnight we can come back with the chair of PPC and other members, and also you can give us some rulings about what principles mean, sir, because I'm confused.
So we have a proposal on the table. I don't think another proposal can take precedence in standing orders, can it, sir?
Well, it's a proposal to adjourn, which I will put to the vote immediately without debate. It's purely procedural. I'll ask the greffier to open the voting. Those in favour of adjourning now, please vote for. Those against adjourning now.
We just clarified the time, so we've got 10 minutes left of ordinary work, haven't we?
Yes. So if you want to adjourn, please vote pour immediately. If you want to continue, then please vote contra. I'll ask the greffier to open the voting. All members with the chance of casting their votes after the greffier to close the voting. And the proposal to adjourn now has been rejected. 12 votes pour, 31 votes contra. So the debate continues.
So can I ask for the 12 just out of curiosity?
Those members voting for the Connetable, St Lawrence, St Clement, St Juan, St Mary and St Saviour, and deputies Luce, Gorst, Moore, Osoph, War, Wilson and Andrews.
Does any other member speak on the proposition? Deputy Rob Ward.
Thank you, sir. I was going to speak very briefly to say, actually, I thought I had this sorted and I could look at the principles I was unhappy with, as I spoke earlier, I said it earlier. But I've got to say, unfortunately, and I mean this in the nicest possible way, Deputy Tellier has a very good point. And he has exactly used a reference back for the right reason. We are unsure as to what we are going to agree in the principles on. There are two very clear areas. I don't think it's beyond those two areas, to be quite frank. There might be a mild things in other areas, but here's the two key points that he's mentioned. And referencing that back will give PPC an opportunity to take control yet again of what we are debating here. We can then come back, agree the principles with the changes that may be necessary and move on. If the principles are agreed, and some people will vote against these principles because they're not in the right position, and then if it fails, the whole thing is lost. If it doesn't fail, it then goes to the long convoluted, or could be, because everyone's very, very busy, the convoluted process of scrutiny which could happen. There have already been issues around other areas that were raised, and we'll end up going backwards very, very quickly. I think a reference back even to the next sitting, if possible, so that we can get some clarity before the next sitting, that would speed the process up. We'll all know where we are, then we can agree principles, and if people want to bring amendments to that, they can by the next sitting. So I urge people just to vote for the reference back and we can move forward, if that's not a contradiction. Thanks, sir.
Does any other wish to speak on the proposal to refer this back? I call upon Dr. Telly to reply.
Thank you for that. I think that was helpful, Deputy Ward. I think that's the point. The first thing to say is that if scrutiny were to call this in, so that's one of the choices here, it's either referred back to Privileges and Procedures Committee where it came from, i.e. come back and do it in a form that's, better, or refer it to scrutiny. And the problem is scrutiny would be scrutinising something which wouldn't normally be on the table if PPC had been allowed to relodge, having reconsidered and taken in the comments that they've heard today. So all these comments would be a waste of time. Scrutiny will look at this and they'll say, actually, there's a problem with deleting Article 11 and actually not giving people access to the electoral roll. And PPC will say, we know that because the Assembly already told us that. And then that would get referred back to PPC. So it would be a much longer and drawn-out process. Unnecessarily work will be taking place, I would suggest. Whereas the message here is very clearly to PPC that there's some fundamental flaws in this, which is not it is a criticism, but it's not an undue one. Please go back and bring it back to the Assembly. And the point about not waiting to vote for the principles is because I think the articles and the principles are so intrinsically linked here that they wouldn't necessarily make sense unless we know what's coming back in the articles. And if, of course, And we refer things back all the time. If ministers bring something forward which doesn't make sense and has got holes in it, we give it back to them and say, do it again, bring it back to us when you've done the job properly. Then we'll scrutinise it if we need to. And that will be the point at which it can automatically be referred to scrutiny, or we can refer it to scrutiny. But I would suggest that actually, once PPC have given this a second thought, they'll come back with something which is much better, which would probably get the majority support, if not unanimous support from the Assembly, but which can still be scrutinised. So I do ask to maintain the reference back to PPC. It's not a political game in any way. I've been on PPC. I think they've got a tough job. I think it just needed a bit more consultation, which clearly wasn't done on this occasion, but they've had the quite clear feedback from the Assembly initially. That's the Assembly's job as well, is to give that feedback. I maintain the proposition, sir, and ask for the appel.
Appel has been asked for. Members are invited to return to their seats. I ask the greffier to open the voting on this proposition to refer this matter back. If all members have the opportunity of casting their votes, I ask the greffier to close the voting. I can announce that the proposition has been adopted. 33 votes for, 12 votes contra, and 2 abstentions.
I propose the adjournment, sir.
Members content to adjourn now? Assembly is adjourned until 9:30 tomorrow morning.